CD. No, CD not list again. Ask him. Now, from now on, it will be difficult to get CDs on time for 15 August. All right. Hmm? 30. Ah. Advocates are different, but what is the why is it wrongly listed? Because another date has been fixed. Huh? For now, let us adjourn your matters. Let them come because in their absence, I do not wish to. 30, 33, 34 list on 28, huh? 27, 8. Okay. Good day. Yes. Hmm? Good day. Okay. All right. Third. Huh? All right. 21. Vote. CDB retain. CD will retain. Item. Uh, when will you be there? Yes. 20. Receive. Hmm. I'll read next week. Five zero. Today is it received? This year as called for has not been received. Is your name? How do where have you come into the picture? It is against you also. Main accused is Anwar Hussain. Anyway, main accused has been released. It order dated 27/7. It would be first para, second para, third para. Third para, as per the allegation, PT Hussain. ইয়াতে যোন আছে তাৰ নামটো দিব Hussain, third para. How many days now? Huh? 2 days. The third paragraph, having regard to the fact that the co-accused of the case, including the person from whom the contraband was actually recovered, have been granted bail by this court. And as the case paragraph beginning case. প্ৰথমখনৰ পৰা কলো। It was recovered from your house, I think. That's all right. CD.
Please, Your Lordship. Lordship, the allegation of some irregularities in the tender process for procurement of 129 vehicles under the Assam project on forest and biodiversity conservation phase 2, Lordship. Lordship, so far the present petitioner is concerned, Lordship. The allegation is that at that relevant point of time, the petitioner was the vice president of the company, namely SBL Knowledge Services Private Limited, who got the tender, my lord. It is alleged that some documents were submitted which were forced documents to get the tender, my lord. This is the allegation, Lordship. So far, the petitioner is concerned, Lordship. Petitioner is already cooperating with the investigating agencies. He has appeared on 2 occasions before the investigating officer, Lordship, and his statement has already been recorded, my lord. And one more thing, Your Lordship. Prior to registration of this FIR, petitioner was the first person to report these anomalies to the police by lodging a written complaint, in fact, Lordship. That I have also annexed in this petition, my lord. Therefore, Lordship, my humble submission is that in this case, my lord, custodial interrogation may not be necessary, Lordship. Already 2 accused persons, accused number 1 and 2, has already been granted anticipatory bail, Lordship. Your Lordship will find the FIR at page 13, my lord.
And where is the apprehension, Manal? He to appear
No,
twice.
there is still an apprehension, Lordship. At the subsequent stage, he may be arrested, he may be detained, my lord. However, my lord, I have extended my complete cooperation with the investigating agency, Lordship. That your
Where
lord,
is the order?
Lordship.
Earlier, somebody has been granted
Yes,
anticipatory
Lordship.
bail.
That order, may I pass on it, Lordship? 2 accused persons are already granted, Lordship.
Who are you? You are the supplier. You are
No,
one of the bidders.
yes, Lordship. And we got the tender and we have also fulfilled the requirements, Lordship. Subsequently, this FIR was registered. And I have lodged a complaint before the police that some persons have submitted some documents in the name of petitioner by forging his signature, Lordship. That I have lodged prior to registration of this FIR, my lord.
But after discovery of the documents, who is going to lodge false certificates in your favor?
Lordship. No, someone has that is a
You submitted the tender. Along with the
Yes.
tender, you submitted certain documents which were found to be fake
yes, Lordship.
after investigation.
Yes, Lordship.
So in your tender, who else is going to submit those documents? It's you
There
only.
is some middlemen are also involved, Lordship. There are many accused, all total, Lordship. There are 8 accused persons, Lordship.
He is the vice president of the.
I was the vice president at that relevant point of time, my lord. Lordship, may kindly consider that, my lord, I have already appeared. I have stated in my petition, my lord, paragraph number 6, Lordship, on 16th of July and on 18th of July, Lordship, pursuant to the notices issued to me by the investigating officer, Lordship. I have complied with the notices and I have appeared, my lord.
Experience certificate issued by SBI. However, the SBI had not issued the experience certificate submitted by the SBI Knowledge Services.
Yes, yes, we remember. It's not very long ago. He granted bail to the other person because he was the recipient of the document. You are the you are the one who submitted the documents.
Yes.
Here the authorities, Lordship, who has
So you don't stand on the same footing.
Same footing.
All right, we'll have the CD only for now. Since you have been appearing and nothing has happened, you don't have any apprehension anywhere at the moment.
I need some interim protection, my lord, since I have already
We are
cooperated.
past, yes.
SCB, my lord, from on 12th, my lord.
Obliged, Lordship.
There is verification. Acquisition is of wrongful assignment of a school girl while it coming from school, my lord. Obscene acts and songs. Certain criminal force.
Also, it is there, my lord, notice.
Subsequent POCSO 8 is there.
Notice and CD.
See, notice.
On it. August, my lord.
Wait, please, your lordship. Lordship will is a pre-arrest bail, my lord. Your lordship will find the FIR, my lord, at page 19, my lord. 19, my lord. It relates to my lord NDPS, my lord. Last page 19, my lord, last paragraph, my lord. During the search of the house, one black-colored black bag belonging to Muhammad Alam Ali was found. Inside the backpack, one packet wrapped with yellow color polythene plastic was found. It contained, my lord, some yaba tablets, my lord. Total weighing, my lord, 753.92 grams.
But it
my
is
lord.
your house.
Yes, that's true, my lord. But I have made a categorical statement, my lord, if your lordship pleases, my lord, at page 6, my lord, paragraph 4, my lord.
It's commercial quantity.
Commercial code.
CD.
I'm obliged.
My lord, from Sapor, my lord, on 18.
Similar matter which is listed for lordship today, kindly matter will be
My lord,
put together,
I
lordship.
am appear some confusion was regarding item, my lord. Another item was fixed on in court number 9, my lord, and that matter has been adjourned for 2 weeks, my lord. This matter may kindly be tagged with that matter, my lord. Criminal petition number 208/2026, my lord. Out of same incident, my lord. Two
Right.
We adjourn today and then. take-
Submitted that similar matter arising out of the same FIR. No,
out of same incident, two FIR was lost, my lord.
arising out of the same incident
Criminal petition.
has been fixed on.
After 2 weeks, my lord.
No date is there.
Not late.
We'll give a date because you are having an interim order. Been directed to be listed has been fixed after 2 weeks. Hence, list this matter along with
Criminal petition 208,
208 of
26.
26, my lord.
26 on give a date after 2 weeks.
Interim order.
Interim order to continue till the next date of listing.
My lord, in this matter, senior counsel Mr. ARVO will appear. So kindly take up the matter after some time. He is on lag, my lord. Obliged.
May I please, Your Lordship? My lord, in this matter, my lord, ISKCON of the TCR is, but much earlier. My lord, kindly call for the up-to-date ISKCON with the TCR, my lord. And my lord, another prayer is, my lord, kindly allow me for filing additional affidavit, my lord.
Submitted that the TCR is of a much earlier period. Call for the updated TCR list again on give it.
And kindly allow me for filing additional affidavit, my lord.
If you can file anyway, what permission is required for that?
Obliged. My lord, please, first week, my lord, first week of August, my lord, if possible, my lord.
Not possible. Yes.
Please, Your Lordship. Regular bail application, Lordship. So matter pertains to recovery of commercial quantity of NDPS substance, Lordship. Lordship will find the FIR on page 18, Lordship. There, Lordship,
Recovery was made from whom? You.
has two petitioners. Both the petition subsequent recovery 235 gram from one petitioner number 1 and from petitioner number 2 234 grams, Lordship. Suspected to be heroin and brown sugar, Lordship. Was
So?
found the FIR, Lordship. Lordship has found the FIR, Lordship.
Yes.
Lordship, here I have taken 2 grounds, Lordship, regarding violation of Article 22, Lordship. The rest detention period exceed 24 hours, Lordship. Lordship will find that in the FIR, Lordship. Lordship, initially the search was made on 18/3/2026 on 6:10 AM, Lordship. 18/3/2026 on 6:10 AM, Lordship. And thereafter, Lordship,
Search was made.
search was made, and thereafter recovery was also made. And subsequently, Lordship, the apprehended.
Where is that? 610?
In the FIR, Lordship, first para, Lordship. First para, Lordship. On third line, Lordship. DD reference that today around 6:10 AM during a checking conducted in coach B13 train number so and so, which has stated platform number Gauhati, they recovered a huge quantity of suspected heroin. And subsequently, they were been apprehended, and that has been mentioned in the last para of the FIR, Lordship. And seizure were made on what the seizure list were prepared on 8:55 AM and 9:40 AM, Lordship. Formal arrest was made on 18/3/26 at 9 PM, Lordship, according to arrest memo. And Lordship will find that the notice 47 itself was served after 24 hour, Lordship. The time that has been mentioned while serving notice 47 is there in the Case 37, Lordship. The 47 notice was served on 19/3/26 on 12:05 p.m. to petitioner 1 and petitioner number 2 on 12:10 p.m. 19/3
12/5, 12/10.
12:05, 12:10. It exceeds the apprehended time, Lordship. Once the petitioners were ought to be supposed to be produced before the learned court below on the 18/3/2026 itself, but they were produced after serving of, even after serving of the notice also, then also 24-hour exit, Lordship. Formal arrest according to arrest memo is 9 p.m. 18/3/26. Today it is 135 days, Lordship, behind the bar. Charge sheet has been laid. Days of appearance, production, Lordship.
Yes, PP. What
My
to
lord,
do?
Lordship, may kindly see, my lord. Information was received on, my lord, 6:15 p.m., my lord, in the morning.
10. 6:10 FIR.
Yes, 6:10 a.m., my lord. My lord, thereafter, my lord, there are some formalities, my lord, which has to be, my lord, performed, my lord, in case of my lord, NDPS case, my lord. So, my lord, they were as party, my lord, arrest memo, my lord, that I have already flagged, my lord. They were sent, they were shown, my lord. Arrest memo was served on 18/3/2026 at 9 p.m., my lord. Date of arrest, my lord.
That you served arrest 47 notice on the on 19/3/26 only.
19/3/26 because they are from Bihar, my lord. Nobody.
Oh, 47. What does it matter whether they're from Bihar? He is in your custody.
He's in our custody, my lord. But my lord, there are some.
And
formalities, my
so
lord,
you
that
have to
has
serve
been
it 2 hours before remand. So for 12:10, that means you produced it at 12:1, 2, not before 2:10.
They have produced him, my lord, on
19/3.
19/3/2026, my lord.
19/3.
Yes, my lord.
19/3 after 2 p.m.
Yes, my lord. At 2 p.m. my lord. Question is that, my lord, what prejudice has been caused, my lord? That is the first. This is my first submission, my lord. Secondly, my lord.
Where from do you say
person-
prejudice in
person,
respect
they were
of
arrested.
these cases?
Accused person, my lord, they were arrested from train, my lord. So, my lord, after recovery, my lord, some formalities has to be completed, my lord, before shown the marriage, my lord. So it took some time, my lord. That is why, my lord, his lordship is filed, my lord. Date of arrest is 18/3/2026, 9 p.m., my lord. So, my lord, they were produced within 24 hours, my lord. Next day, 19/3/2026.
But
Only
this
as per
time,
the FIR, my lord, the information received on 6:10 a.m. in the morning, my lord.
Regarding that, Lordship,
information is received that they have already been apprehended.
Apprehended, my lord, means, my lord, they were initially, my lord, the contraband was found, my lord. Thereafter, my lord, it has to be searched, my lord. Then they have to taken down from the train, my lord. Thereafter, my lord, there are some formalities in case of NDPS case, my lord. That has to be performed before forwarding them to the judicial custody.
That should have been mentioned at what time it is
As per the arrest
completed.
memo, my lord, it is clear, my lord. Date of arrest is on as 9 p.m., my lord, and they were produced on 19/3/2026, my lord.
That is only formal arrest shown. That will not do. That has been laid down already.
So, my the forwarding report, my lord, while they were initially produced, my lord. That is page number 23, my lord.
Twenty-three is order.
Order, my lord, while my lord, they were produced before.
Yes.
7 and 48 notice has been seen by the concerned magistrate.
Yes, so 47 notice has been seen. You served 47 notice at 12:10 PM. That means it was produced after 12:10.
Yes, my lord.
Then-
12:05, my lord. As per the notice, my lord, 12:05 PM, the notice was served, my lord.
No, 1:12:05, 1:12:10. Two are there.
So, the case of NDPS, my lord, he knows for what purpose he has been arrested, my lord. Know that, my lord, he has to, my lord, serve notice.
No, we are not on 47. 47 is referred to only for the purpose of showing the time. Not that 47 was not served. It was served, so you don't have to defend that. Okay, we'll pass orders.
Deeply obliged. Lordship.
যেটা করেছিল কপি এটা নিয়ে দিবি কাগজ তো রাখি তো
My lord,
Item 10, my lord, search is submitted.
my lord, in this case, 120 days he is behind the bar, my lord. So it's as
What is the offense?
my lord, regarding counterfeit coin, my lord. First counterfeit coin.
Fake currency.
Yes, my lord, fake currency.
Earlier rejected.
Yes, my lord, earlier rejected as Honorable Mrs. Justice Mitali Takuria is on sick leave. That's why I prayed before Chief Justice to reassignment of the bench, my lord. Accordingly, this case.
Let's say TCR. Submitted that CS has been submitted by CS number so and so. Can copy of the TCR.
Lordship, kindly this matter may be passed over for a time being, Lordship.
For 12. Search is submitted, my lord.
Let him come. He may want to appear also.
I think, my lord, we have not received the case that I has paid for some time, my lord.
In the meantime, we will file an additional affidavit that may be allowed.
Sure, but LPP submits that IO has sought further time to submit the CD. List the matter again on.
I hope so.
Deeply obliged.
We do.
Type is a loss. Regular bail application, my lord. And for the 54 days is in custody, my lord. And offense, my lord, is a 60 days offense, my lord. And here, my lord, the FIR is at page 9.
Yes, my lord, POCTO is there, my lord. Report we have received the case, my lord. Then, my lord, it is service report is complete, my lord. Yes, my lord, yeah.
Report of service is complete. Service on respondent number 2 is complete. What about TCR? TCR?
Record, CDS.
CDR.
It is received, my lord.
CD?
Yes, my lord, CD received.
CD also received. And so is appointed as amicus.
Lord, section 14 of POCTO has been added, my lord. The prime accused has been released on bail. I am shop owner, my lord. And my device was used by the main accused, my lord.
All right, we'll have it Monday
50
or we have to go through the process.
In the earlier also one occasion also, my lord, after service completed, my lord, they did not appear. And prime accused was released on bail. paragraph 2, my lord. Second. The forwarding report also, my lord.
This is whose order?
By the learned session judge, my lord.
Oh,
There also they did not appear after service.
trusted in ignorance of the law. Yes, Monday. So any amicus listed present? Keep for us. You serve copy. We'll take up on Monday.
First.
Tuesday, my lord, because he has received the.
No, Monday maniac is this release. That
Monday,
is why we want to see.
Monday.
Respect of my lord, item number 30, 33, 34, my lord, that was already adjourned, my lord. Then it was wrongly submitted, my lord, that the matter has been fixed on 27/8, my lord.
No, that was not given. It was just said for 2 weeks or something. Oh, 27. Yes, yes.
They have mentioned that 27, that is why, my lord, these three matters were adjourned, my lord. But we have checked the record, my lord. As per the order dated 77/2026, matter is fixed today, my lord. All the matters are fixed today, my lord.
In different courts.
But this honorable court, my lord, on 77, my lord, this matter was taken up, my lord. And my lord, that was fixed on today, my lord.
Call the petition.
Please, your lordship.
Maybe some date was pronounced and in the order some other date got reflected. Can happen like that also.
Fixed on 27/8, matter may be taken up on.
They may have heard 27 at the time of pronouncement, but maybe
by the
the
record.
different date came to be recorded. 27/8.
They have mentioned so, my lord.
That is 1 month away. Bail.
That's what I have heard, my lord.
Is a regular bail.
Anticipatory bail, my lord.
Any interim order is there? Oh, then how can it be so long? CD is also here. Oh. Call. Yes.
Please, your lordship. Lordship, in this matter, TCR was called for, but as per the cause list, it is not there.
The TCR is
Your
called
Lordship,
for has not
I'm
been.
appearing for the respondent number 2.
Lordship, it is
Today, we are filing for an objection.
Lordship, it is the
Learned
second.
counsel for the petitioner TCR is called for has not been received. Registry to issue reminder. Sir, so and so learned counsel enters appearance for the respondent
Lordship.
number 2. Is for time to file objection. Release the matter again on. Yes.
It is the second time, Lordship, TCR has not received. And it is from the Kamrup Metro Session POCSO Court. Lordship.
Where is it to come from?
Lordship, Kamrup Metro, Special Just POCSO.
Since this is the second time that the here has not been received, the learned special judge POCSO Kamrup Metro directed to ensure transmission of the scanned copy of the TCR the next date fixed. To communicate a copy of this order to the learned special judge POCSO Kamrup.
Lordship, a short date may be given kindly, Lordship.
Quick.
The petitioner is behind the bar for the last 257 days, almost 8 months, Your Lordship. A search sheet has been already filed, investigation has been completed, Your Lordship. May be allowed to go on trial, Your Lordship.
Is the FIR?
FIR is at page 12, Your Lordship.
Yes, PP.
And so that, my lord, LCR, my lord, but my learned friend said that TCI is received, my lord, because it is not shown in the cause list, my lord.
Here is here.
Yes, TCI is here, but it's not reflected in the cause list, so I could not see, my lord.
Look,
But-
183.
This is item 18, isn't it?
Yes, Your Lordship.
Says which scan TCR.
Office note, my lord.
Office note fixed which scan TCR.
Only that with office note.
Look at cause list.
Lost it.
Yeah, but-
With office
Huh?
note fixed. That is lost. Is
I think this was inserted later on.
later on, my lord. Perhaps it came later on, my lord.
Not at 9.
Oh.
That is so.
My lord, let
Lordship,
me
it's
either to.
detention of the period, Lordship, is a local person of that locality having minor kids, Your Lordship. The detention is in the detention of the period of the, he may be allowed to go on beyond, Your Lordship. At any condition, Your Lordship, may deem fit and right, Your Lordship. There is no, in the search sheet, Your Lordship, may kindly look, there is no specific result in the medical, Your Lordship.
Lordship, she is 7 months pregnant.
She is pregnant, but who is the actual father is not nowhere found, Your Lordship, in the medical report.
It is open for DNA testing only, Lordship. In her 183 statement, Your Lordship.
Medical, Your Lordship, the paternity has not yet been determined, Your Lordship.
Hmm?
The medical report, the paternity has not yet been determined, Your Lordship.
DNA test was done. How will paternity be determined?
Can be done only after the child is born, Your Lordship.
Then I may be allowed, Your Lordship.
He was declared hostile. Although she stated, took me to a jungle and raped me. Thereafter, I came home and told my mother. At this stage, she was declared hostile. After that, she again began singing. She named 4 other persons. Anu Pradhan, Ranju Tamang, Sumit Kormakar, Mukund Borai. Series of persons.
Persons.
Everybody committed rape on her. Different dates.
Fact being she was pregnant at the time of medical examination. Fact is just, my lord.
But pregnant
something
by
is-
whom?
Yes, there is something has happened. Is my lord, prima facie something.
He says another, he names out of the 4 persons, says accused Sumit Karmakar had not taken me away forcefully. I had gone with him myself. Later on, again, he says it is not a fact that he did not take me forcefully. What reliance can you place on such a witness? Keeps changing the story in course of the same examination. How many days in custody now?
Today it's 257 days, your lord. I was arrested on 15/11/2025, your
What
lord.
about the other accused?
They are still behind the bar, your lord.
The counsel for the petitioner. And the additional PP also heard. 1200 amicus. Hearing for the. And this is an application. Investigation of the case. And the trial is presently proceeding, and the deposition of the victim has also been recorded. The present petitioner along with 3 other co-accused have been charged under section 64 within bracket 2, again within bracket small m, plus 3 within bracket 5 BNS. And under section 6 of the POCSO Act on allegation of commission of rape stroke penetrative sexual assault upon victim. Para has spent 200, how many?
257 days, your lord.
257 days behind bars. Having regard to the on record, the progress of the trial. I'm of the view that the petitioner be released on bail. Therefore, bail is allowed. Provided that the petitioner shall regularly participate in the trial and shall not try to tamper with the witnesses, remaining witnesses.
May it please your lordship.
Lordship, this is a regular bail application, Lordship. In this case, this petitioner in jail custody for 7 months. That is 214 days today, Lordship. FIR, Lordship, will find on page 19, Lordship. Case was charge sheeted, Lordship. Out of 8 witnesses, Lordship, 4 has been examined, Lordship. I have annexed the evidence of the 4 of the witnesses, Lordship. Now, Lordship, the Caesar witness, Lordship, did not support the case of the prosecution, Lordship. They said they FIR on
It
page
is otherwise what, commercial quantity?
It's a commercial
quantity, but 20 kg, 431 gram. It is weighted along with the plastic bags and snack.
Anyway, charges under commercial quantity, no?
Charges under commercial quantity. Now,
But
my
it's-
lord, 4 has been, my lord, they here annexed, my lord. Now 6 witness examined so far. On 27 last also, my lord, examined, my lord. Trial is the verge of completion, my lord.
PW Lordship 1 and PW 1 and 2 Lordship, Caesar witness on page 37 Lordship. Cross portion on 38 Lordship. Now the weight of the Lordship, the ganja has been measured with the Lordship bag.
Hmm?
With the bag it was contained, Lordship, not net weight was given in the forwarding report, Lordship. In forwarding report, Lordship, will find on page 21, ground that is on page 22, Lordship, para 5.
You are relying on PW?
PW 1 Lordship, that is on page 37 Lordship. Caesar witness, Lordship. Cross portion on page 38.
Chairman, which PWs has to be relied and which not, my lord. But that
Caesar
may
Lordship.
cause, my lord, hamper the trial, my lord, regarding this. The appreciation of evidence, my lord, that will may hamper the, now, my lord, since only 2 witnesses remain, my lord, very likely, my lord, next month, perhaps, for the judgment also, my lord.
38 is the Lordship, is cross portion, Lordship.
Yes.
Without going to the merit.
Which para?
Ah,
Cross.
Cross Lordship. It's a small 1-2 Lordship. When I signed the Caesar list, my name and address and my father's name was written. Nothing else was written. I signed the Caesar on such and such. The color of the sack was probably white, but in the Lordship forwarding it is say blue. I heard the sack contain bhang. Yes, they say it is a bhang, but I did not see the bhang in the sack with my own eyes.
Now, where does he say it was weighed with the sack?
That is their Lordship. 5 Lordship.
Huh? He did not
That
say
in
it
the
was weighed
forwarding,
with the
Lordship,
sack.
in the forwarding it is a Lordship. It's a in Caesar and forwarding Lordship. It is a Lordship. Caesar Lordship forwarding kindly see Lordship page 22, paragraph number 5, including polythene bag. Total weight has been given, including polythene bag.
If it is polythene, then it can be.
But Lordship in
One
the
bag.
Caesar
One
Lordship.
bag only.
One there no Lordship. 5 bag is there Lordship. Caesar Lordship. May I take you the Caesar Lordship?
5 bag.
4 bag.
4 bag.
Caesar Lordship will find on page 25 Lordship.
Section
Page
number.
42.
Page 25 Lordship.
No, see, polythene bag was opened and ganja was found inside the bag. The ganja was weighed and it was somewhat more than 5 kg.
But Lordship, there are several bag Lordship, 4 bags Lordship. Yes, there in for Caesar
No,
list.
at least
That
there
is
is a
on
witness who
25.
says it was weighed with the ganja. Not with the
Here,
polythene.
but Caesar said lordship total
There
weight.
was no suggestion it was weighed with the polythene. So
Before the charges also, my lord.
Now
No,
the
my lord, this,
Caesar,
this factor not brought before the trial court, my lord. Only now, my lord. The stage of.
If
now
that-
being brought.
these are all appreciation of evidence. In bail, we cannot, unless
Cannot.
there is something glaring, we
Lordship.
cannot.
next Caesar
It will-
witness
it
on
will affect the
39.
decision of the trial court if we make observations regarding.
Lordship. That is what my son.
Figure in page 40 lordship cross portion already another Caesar witness lordship.
We can't go to all of that, no.
I do not know from whom's possession of the ganja was found.
You may have a good case in trial, and we don't know
Already lordship
don't-
7 month lordship since it's
how many witnesses are there, but we cannot say at the, even now 37 is attracted.
lordship,
we cannot say there is
polythene bag-
reason to
but
believe
the
now.
lordship, the weight was measured lordship for lordship, including that polythene bag. Had it been lordship weighted to the net weight, that polythene bag may be reduced to the lordship below 20 kg lordship. It may come under lordship
Those are
intermediate quantity.
maybes, these are maybes which you have to prove.
But they have
the
given
trial.
the weight along with the bags lordship.
Even without the bag, it can be above 20.
The 431 gram for the weight of the other lordship that was there because the commercial quantity lordship 20 kg lordship.
Is nothing
Above that,
specific.
that is the things lordship. If that portion is deducted lordship, maybe
Which
it come under.
where are you quoting
intermediate.
from? It was weighed with the bag. Where are you showing from? So there were 4 bags.
4 bags.
4 bags. So one is 5 point something, next is 5 point something, next is 4 point something, and the last is 20 point something.
Yes.
So
Last is
34 kgs.
No, lordship. Total 20.
No?
Yes, lordship. In the Caesar list, lordship, can we see?
20.43.
Is the total weight?
Yes.
Total weight is 20.431.
Anyway, now we cannot decide what is the weight of the plastic. That is what you have to prove.
That benefit lordship goes in favor of this petitioner
Oh,
lordship
how
because that
benefit?
weight was not lordship properly given. Net weight has to be considered lordship, not the along with the container lordship. And 20 kg ganja lordship is not an small amount lordship which can be measured without container lordship, without bag lordship. So bag, they have definitely done it in the bag lordship.
Where is the charge sheet?
Is 23 onwards lordship, 23 to 25. type copy, Lordship, in the certified copy that is on page 26, Lordship. Only.
Where page?
Page 26 onward, Lordship.
Charge sheet.
Charge sheet, Lordship. And description as in that is on certified copy in page 34, Lordship. Vernacular, Lordship.
There are only 8 PW, 6 have been examined.
They examine.
The trial is almost over.
That is what.
It will not be safe.
Only scientific officer and another official witness is there. It is likely to be committed within 2 months, my lord. So at this stage, my lord, appreciation of evidence may take the trial. My lord. Because already 22 under commercial quantity.
But the
charges were
Caesar
framed.
witness did not support the case of the
Charges were framed.
prosecution.
Thereafter, trial is going on. They never made any suggestion. They never took the plea at the time of framing of charges.
Heard learned counsel for the petitioner. Additional PP decision application under so and so. The prosecution case briefly put is that on 29/11/25, .431 kg of suspected ganja was recovered from the possession of the petitioner. In Nauboisha area, Lakhimpur district. The learned counsel for the petitioner submits that the quantity is of ganja seized is marginally above commercial quantity. And it is further submitted that the weight of the ganja was taken along with the polythene packets in which the ganja was kept, and therefore the stated weight of 20.431 kg is not the net weight of the ganja. And if the same is, and if the weight of the polythene packets are deducted, the ganja would be within intermediate quantity. Para A. On the other hand, learned additional PP has submitted that out of the 8 listed witnesses, 6 have already been examined and only the scientific officer and the IO remain to be examined, and therefore the trial is on the verge of completion. The charge against the petitioner also gets to commercial quantity.
And words of section 37 will come.
Therefore, section 37 of the previous act is attracted. full stop. Whether the weight of the ganja comes within commercial quantity or immediate quantity is to be decided finally at the time of trial. And having regard to the fact that the trial is on the verge of completion, it would not be proper to release the petitioner on bail at this stage, regardless of the category in which the quantity of ganja falls. The prayer for bail stands.
Obliged, please.
May I please your lordship?
Charge
Charge sheet, my lord, one thing, my lord, I am the owner of the hotel. I stay in Manipur. My hotel is being run by the other managers, and there was a party in the hotel on that night, birthday party. And one 17 years girl was found spend the night with one of the co-accused, my lord. And that is why POSCO has been added. How owner can be implicated? And there is in the order passed by the learned session judge has reflected that proper maintenance of the register of the hotel was not maintained, and name of the persons were not recorded who will stay in the night. And for that, my lord, it is a offense against the manager, my lord. How the owner, who is a contractor in Manipur, has brought out and taken into custody, my lord. Last, he is behind the bar, my lord, since
70 days, 70 days.
70 days, my lord. His wife has delivered a child, my lord, in the meantime, my lord, because she was on family way. There is none to look after the wife even. All for this point of, my lord, I pray that at least owner may be considered the bail, my lord, at least. I am for the owner of the hotel, my lord. And notice has been served to the informant also, my lord.
Yes, I am for the informant.
What is your name?
My name is, my lord, Nazir Ahmed Chaudhary. I am owner of the hotel, my lord. Manager was taken into custody, or we have got no objection. Let him face the consequences if he has done illegality. And the guard was taken to the party by one Victoria. And this Victoria has called the police again. Lordship, order sheet of the Honorable Section Judge reflect that matter. The guard was a student of higher secondary, 17 years as reflected from the FIR.
I come to page 22, my lord. Owner, my lord.
Yeah, I am owner of the hotel, yes.
Owner, my lord, forwarding.
How do we know whether you are staying somewhere else or
I am Manipur, my lord.
near the hotel? We don't know.
Done by manager, my lord. It is no doubt my hotel, my lord. I am the registered owner of the hotel.
But his allegation against him, my lord, also may kindly come to forwarding, my lord.
Yes, money goes in my account. That is the return, my lord. Naturally, hotel account is maintained by me, my lord.
Who knows, you may be hand in glove with the manager. Let us have the TCR.
Against the notice accused, gathered incriminating evidence as based on statement of the minor victim, my lord.
My lord,
Let
to
us
my
have the TCR.
information today, that a case has been charge sheeted.
We know, that is why TCR.
My lord,
We need to see
I'm
the
facing-
statements of the victims.
My lord, your lordship will definitely appreciate. I am owner of the hotel. My lord, if your Radisson Blues head office is in Yugoslavia, their head office in Indian head office in Delhi.
You, Mr.
No, but
Vishwas, you are not
just for
Radisson
argument
Blue.
sake.
You are not Radisson Blue.
No, but even then hotel, my lord. I am a owner of the hotel.
Don't compare owner of Jonta Hotel with owner of Radisson.
Not Jonta Hotel,
Yeah.
my lord.
So we also know owners are how owners are hand in glove with these people. They keep one manager and then claim.
My lord,
Yes.
since it is charge sheeted, it may be closed, madam. It will be closed, madam.
Closed.
Yes, I will try their account.
All right. Very good. I see Vishwas Learned Counsel for the petition. Learned additional PP submits that the case has been charge sheeted by CS number. So
20/26 dated 9/7/26.
Sir Vishwas submits that the petitioner shall apply for regular bail before the learned court below. The petition stands closed. Yes,
That's
And for the information.
Spencer appears for the information.
May please, your lordship. Lordship, last 72 days, lordship, this petitioners are behind the bar, lordship, their husband and wife, lordship. Petitioners are, lordship, husband and wife, lordship. And petitioner number 1, she belongs to lordship Buxar district, lordship, and petitioner number is her husband. 2 is her husband. He is from lordship Maharashtra. Lordship. They came to lordship visit a marriage ceremony at Buxar, lordship. And lordship will see the affair at page 15.
this report is incomplete, my lord. Is sent, my lord. The last occasion.
So who is in jail now?
What this petitioner?
Both. Very expensive marriage.
Lordship, this not the expensive, lordship. See, that is her matrimonial house, lordship, her house at Buxar, lordship. And this petition number 2, lordship, he accompanied his wife, lordship.
But notice on respondent number.
Respondent number 2, lordship, he is the
Two.
police officer. Probably, lordship, this Pepi will
Who?
represent this. Respondent number 2, lordship.
Who is police officer? Where is the victim? Have not made the victim a party.
And
But on
this
the
is first
inform-
10, my lord. He's an informant. Informant or victim, my lord.
Government, but the victim has to be made a party, is it not?
Yes, my lord, but as per the my notification, informant or victim or guardian, my lord. That is,
But we have to have some
Sir,
common
Lord-
sense.
Lord-
If the informant is a police officer, what is the point of making him a party? If it is not the victim. Informant means
Now-
a victim, or informant means if informant is victim's father,
The-
mother, or something like that. If
The-
it is a complete stranger, what is the
Because
point of
vic-
hearing the, how do we hear the victim?
Lordship, this victim is lordship go by the affair. There is no victim because this person who has been lordship interrogated by police, they are basically not victim, lordship. They just lordship this one number lordship Bhavana
Bhavana Vishwakarma.
Bhavana, yes.
So notice has
She-
been issued to her.
my lord.
She has no even probably lordship.
Steps, my lord. Steps. Informant he is taken.
Huh?
Notice where my lord taken on informant. So my lord, victim has to meet other victim or her guardian, my lord. Meet party, my lord, in that case, my lord.
Question, lordship, is that whether the statement made in the affair, whether those persons are victim, lordship. They are not victim at any way, lordship.
This for the purpose of the notification, she is a victim.
Lordship, that is what I'm saying, lordship, in the affair, the statement that made in the affair, only the police lordship, suspected some girls, lordship, they are Hindi speaking girls, so they were roaming in the Buxar district. Accordingly, they lordship interrogated this girls. Basically, the girls lordship are a tenant of this petition number 2 at Maharashtra. So lordship, the tenant lordship, they have no allegation against us lordship. So how can we the victim lordship?
Page 18 is the reason of arrest, my lord. Here it is stated, that Tutumoni and Anijadov has been specifically named by victim Bhavana as the individuals who confined her and compelled her into prostitution.
Lordship will see if that statement is made by this person, why she has not lordship lodged any complaint after coming to Assam lordship from Maharashtra. In her statement itself, lordship, in the FIR and forwarding the police has stated lordship, this Bhavana has Bhavana Vishwakarma lordship. Bhavana Vishwakarma has stated that lordship she was confined, but she lordship returned to Assam along with these petitioners. Why she lordship did not lodge any complaint if she was a victim lordship?
Complaint is already there.
So lordship, there is no problem from our part lordship. If she
No, any
if-
case is already registered, so what
Yes,
is the
it-
point of lodging another complaint?
Anyone can
that's
lodge
not,
it.
no, but I'm not saying that lordship. The complaint was lodged much later this lordship she returned to Assam. She returned to her Meghalaya lordship. Then she again came to Assam.
All right, let the informant. How many victims are there?
He lordship. And others too are lordship not connected with this petitioner loss. They accompanied this
Victim
Bhavana.
Bhavana Vishwakarma has given a clear statement that
Clear
she was
statement.
wrongfully confined and forced into prostitution in Nashik for 2
Nashik.
months. And you say there is no victim.
Lordship, that is her statement lordship.
Of course,
My
we are going by her statement.
lordship, my respectful submission is that lordship, she was assuming that lordship she was confined in Nasik, but she returned to Assam and then went her home at Meghalaya. Then again he returned to lordship Assam to give complaint this petitioner lordship. Why she did not lodge any complaint if we are
Where do
confined
we
her?
get all that? We don't know.
That is why I'm saying lordship, we are
Wherefore?
not she is not a victim of this petitioner lordship. Might be lordship she individually engaged herself lordship in such kinds of activities, but we are not lordship aware about her. Lordship, kindly see the reasoning of her statement, Lordship. She back to her home at Meghalaya. No complaint, no allegation, Lordship, against us, Lordship. After arresting Lordship, she has given this statement that she was confined. And others 2 persons, Lordship, she accompanied these 2 other 2 girls, Lordship. One is major, one is.
You have gone through the TCR?
This year I have not gone through because my lord, since service is not complete, my lord. Yeah. Somebody has to appear, my lord.
Lordship may give them some time, Lordship, and Lordship, if you short date, because 72 days, Lordship, they are behind the bars.
Case has also been suscited, my lord, whether that is. The search sheet is a part of the record, my lord. It was filed on 22/7.
Fully implicated in the statement.
I'm sorry, Lordship.
This long. Had learned counsel for the petitioner. Additional PP. Is to respondent number 1, 2 is not yet complete, but as said, respondent number 2 is a police officer stroke informant. Hence, he is represented by learned additional PP. The allegations against the petitioners relate to running of a prostitution racket in Nasik, Maharashtra, for the purpose of which the victims of the present case were lured to Maharashtra, Nasik from Assam and engaged in prostitution. The case has been charge sheeted and the scanned copy of the TCR has been received. Upon perusal of the statements of the victims, find sufficient incriminating material against the petitioners. Hence, the prayer for bail stands rejected at this stage.
Lordship. Obliged, Lordship.
Obliged. See, my lord, service is not complete. Right?
But here also, my lord, 56 days, my lord, today behind the bar.
Take steps to police station.
Lost.
Hmm?
Could have taken steps, my lord.
How?
Through the registry, my lord.
By post.
No, through the registry by PP office, my lord.
Service and respondent number 2 is not yet.
And my lord, lost from the
Complete.
FIR, my lord, section 12, my lord, is not attracted in this case. 56 days behind the bar, my lord. 60 days offense, my lord. Section 12 has been added.
Huh?
Section 12 of POCSO has been added.
Fixed on Monday, my lord.
PNS offense are available.
Where is the affair?
Page 9. It was 9.
Is 9.
Relevant is page 12. The forwarding report. Page 9. My lord.
Monday. Notice. And number 2 is not yet complete. Learn it. To obtain instructions list again on Monday. Right.
Please, Your Lordship. My lord, seizure of ganja of 1782 grams. My lord, a little bit, my lord, higher than the small quantity, my lord. And now, my lord, he's behind the bar for 24 days, my lord. And I have stated, my lord, that he is a mason, my lord, not indulged, my lord, in these activities.
CD not receive here, my lord. Arrested on my lord 8/7, my lord.
24 date as on date, my lord, 24 days.
24 days. CD may I pray, my lord. A date may be fixed for the CD.
The quantity depends on how much you have been able to dispose of at the time it is found.
Yes.
My lord, in fact,
Lower quantity means higher sale.
my lord, I have stated that the scraps and weeds, my lord, those were, my lord, cleaned and removed, and those were piled, my lord, for setting fire in the premise. And this does not relate to, my lord, any plantation of, my lord, this cannabis or ganja.
As per report, you are engaged in the business for last 3 years.
So, my lord, this I have stated, my lord, this is a statement, my lord, which is absolutely, my lord.
First date, let's see one date. Next week date, give it date.
From Soigaon, my lord.
Kindly fixed on my lord 10th of August, my lord.
10 to 21. My lord,
Yes.
from 3rd to 7 any day, my lord, next week.
7, my lord.
7. 6 করে যা 6. Soigaon pa hai. 6, my lord.
Time, my lord. Time, my lord. 6. 1 on 6.
Soigaon.
Perhaps, my lord 7.
এটা দিছে এটা দিছে এইটো
May I please, Your Lordship?
6.
Lordship, this is an application under 483 of BNS. Lordship, on last occasion.
Here, notice issued to respond number 2, my lord. Notice is incomplete, my lord.
Notice was
CD
issued,
is
but
not received.
the same was not reflected in the order sheet, Lordship. So we were unable to take steps.
Oh, notice you are right.
This was last date of order too.
Wait. To the respondent number 2 petitioner to list again on give it date.
Lordship, both through
List
usual.
again, it was directed to be listed on 18/8, is it not?
18/8.
All right, 18/8.
18/8, my lord.
Highly appreciated.
Hello?
This case, scan copy of the TCR has been got from my but
Not received.
No, my lord.
Scan copy of TCR not yet received. Issue reminder list again on.
আমার metro my lord only.
Right.
Not definitely given. 13. Too long, my lord.
অহা সপ্তাহে আছে
7 August. Okay. Nice.
If my junior has mentioned item number 30, 33, and 34. Some other cases, my lord, that petition pending before this honorable court, my lord, fixed on 27/8/26. So she mentioned
Confused.
that let it come on that day, my lord, along with other petitions, my lord. That was the actual submission, my lord. That number I have, my lord. AB number 135326 and AB number 135426. Some other petitions
There,
also.
no, these cases you have mentioned, they arise from the same FIR.
Same, three FIR, my lord, out of my lord, same, my lord, incident. 3 FIR lost by different authority, my lord. One Saptra Santha, one by Forest Department, one by Social Forestry, my lord. Some subject matter is same, my lord.
In this case, my lord, in all the cases, my lord, we have one preliminary objection, my lord. So during investigation, my lord, section, my lord, 40/2 and 10 of A of the UAP Act has been incorporated, my lord. Application was filed, my lord, and tri-court had allowed the, my lord, to incorporate section 42 and 10A of the UAP Act, my lord. So in view of this, my lord, and as per section 43(2), my lord, 43(d)(4), my lord, there is a bar, my lord, seeking anticipatory bail by the petitioners, my lord. 43(d)(4), my lord.
Earlier, there was not added this section, my lord. Subsequently, when we get interim bail from this honorable court, my lord, they added this section.
So it has become now they can arrest you
That is up to.
because you are only granted
Yes.
interim bail
Now
in respect of certain sections.
Yes,
Now if other sections are added, it is open for police to arrest you.
yes, yes.
So remedy is up to you now. This interim order is as good as non-existent now.
Yes. But it was fixed on 27/8.
No, we can fix it on 27/8, no
Yes.
problem. It is not maintainable because of the addition of the subsequent sections as of now. And anyway, this interim protection is of no avail to you now. So if you like, we can fix it on that day. In the meantime, you can avail of alternative remedy if this one is there.
And
There must be some remedy.
And secondly, my lord, the matter which they have already mentioned, my lord. That matter was already been fixed today, my lord, on 30th. We have checked the record.
Other similar matter, that number I have mentioned, my lord, fixed
Just
on.
number other matters, not these, not listed today.
But then, my lord, the matter which were listed today, my lord, that matter may be, this order may be passed, my lord, that pursuant to, my lord, adding of section, my lord, 40/2 and 10 of 10/A.
Yes.
My lord, there is a bar manner section 482 of the BNSS, my lord.
Yes, what do you want to do now? What, any point in keeping this pending?
My lord, we'll keep it until the next day. My lord, why we say so is, my lord, if your lordship sees the FIR, this inclusion of these provision offences, my lord, is totally absurd. The FIR is regarding, my lord, some allegation regarding stone mining, my lord. Now, if they, as per the whims and fancies, add a particular section, that too not mentioned in the FIR, FIR doesn't disclose which terrorist organization we are funding. Nothing, my lord, just they have said that they've added it to sort of scuttle the
All right, the item numbers.
26 to
26 to
My lord,
34.
that is, my lord, fixing a long date, my lord, we have objection, my lord. Because 27/8 is a long date, my lord. Today is 30.
Oh, if you have added section, you can arrest them. Their protection is only in respect of the existing sections. Then how can you have an objection?
That may be reflected, my lord.
Why will we reflect the law? That is the law.
No.
That is the law laid down by the Supreme Court.
They have to satisfy from the case diary on what basis those sections have been added, Lordship. Mere association with a illegal is not.
Just list all these matters along with those give those numbers.
Yes, my lord. 1353/26 and 1354/26.
1255. 1253.
Till 4.
Item number.
No, not item number. Give the list.
These two cases, my lord, yes, earlier fixed.
Only these two cases, yes. List these cases along with these two cases on.
one.
What is the date?
We'll give a list. 27/8.
27/8.
So since we have already received the case diary, my lord, my humble submission, my lord, let the matter be fixed, my lord, in the next week, any date, my lord, because we have received, we cannot keep the case diary pending for 27/8, my lord.
Send it back for resubmission.
This, my submission may be recorded, my lord, that section 40
Yes,
by.
it is submitted that section.
My lord, section 40 subclause 2 and section 10 subclause A, small a of the UAP Act has been added, my lord.
Been added. It is submitted by learned additional PP that so and so have been added, and hence the present bail application is
Not maintained.
not maintainable in view of section 43.
43(d)(4, my lord.
43(d)(4) of the UAP Act. On the other hand, learned counsel for the petitioner submits that similar matters are fixed on so and so date. Hence, বাকীখিনি দি দিবা, list this matter along with so and so.
Interim shall continue, Lordship, earlier sections.
Will not make any observation
That is
now.
there, already done.
Because law will operate.
But it is still today, so if your lordship extends it, I think it's.
There is a bar, my lord.
Well,
There is a
that's
bar.
a matter of interpretation, whether that interim would apply for the newly added sections or not. But at least for
that,
the,
my lord. Lordship may fix it any date any date, my lord, in the next week, my lord. We'll produce the case diary, case diary, we have received the case diary, my lord. We'll produce the case diary, my lord.
No, we are not extending the interim because they can anyway arrest you. It is meaningless.
but insofar as the.
Since the sections exist, they can arrest you.
But in this section.
At least for the sections which the bail was initially granted. Only.
That may be.
That will continue.
So your lordship may not.
They have done it. My lord, section, my lord, when they moved this application, my lord, this section was not there, my lord. Now they have added, my lord,
Yes.
these two sections of the UAP Act, my lord. Now, my lord, these all bail applications become influxes, my lord. This is my first submission, my lord. Secondly, my lord, if lordship is continued, my lord, their interim period, my lord, then it will be, my lord, again, my lord, after adding section of the UAP Act, my lord, this honorable court has again, my lord, extended their interim protection, my lord.
That is 1 month away. So
Their earlier allegation was that, my lord, about 60,000 trucks boulder going through this road. There is a police station, there is a range office.
simple.
In front of that office, my lord, 60,000 trucks going on. Whether they were paid by the government to count the number of the trucks,
We have.
they have no responsibility.
If you want to
So
argue
this
on
is, my
merits,
lord, now
we can
absurd, my
we can
lord,
take up.
absurd, my lord.
No problem.
When
I am
this
saying,
court,
my lord, that the
this
matter of-
honorable
matter of-
court granted, my lord,
Yeah.
interim, now they added the
Well, in
another
that case,
section.
we concede, let there be an earlier date, but let the interim at least continue. Your lordship will
Yes,
not.
all right, let's have it earlier then.
So next week, any
2
date,
weeks,
my lord.
2 weeks, my lord.
No, Monday, my lord, Monday, my
Well,
lord.
well,
On
2
Monday,
weeks they can wait. My
No,
lord.
no, 2
In
weeks,
fact,
my lord,
in
we have
fact,
received
forest
the case
officials
diary.
are implicated. Are they
Because now,
proceeding
my
against
lord,
them?
the case diaries are, case diaries we have received, my lord, and there is a bar, my lord, in anticipatory bail, my lord. So we are praying, my lord,
All
let
right,
the
Thursday.
matter fix on Monday, my lord.
Thursday, we'll have
Thursday,
it.
third.
Monday, I think already matters are. Is the it will. So we'll simply say list on. I will not say all these things now today.
My lord, will kindly
We'll
observe
extend.
interim to continue.
Yes, yes. List the matter along with the number duta di diba on Thursday diba interim
My
order
submission may be
passed
recorded, my lord.
continue.
Apply.
My submission regarding any of section, my lord, that may be recorded.
Yes, that part you retain.
Quickly.
Please, your lordship. Lordship,
Agreement goal.
this is a second bail application. Can you tell you the FIR? Vinita Nivedan is a MS Shah Brothers Bharat Gas distributor agency. No, matlab here up to date CD not received.
Yes, up to date CD.
Hadgaon PS. Hadgaon PS, my lord, maybe on 11. My lord, I have a humble prayer, my lord. My lord, the mother of the petitioner number 2 and 3. But all the petitioners are family members. The father and the other two are sons. We have been apprehending the arrest because we have done nothing what was stated in the FIR. Now the mother of the wife of the petitioner number 1, she is seriously ill and needs medical attention. So interim may be granted till the next date. No. A humble prayer, Your Honor. Asking for just an interim till the next day.
Interim is always till the next date.
It may be vacated at that point of time if it is seen that there is some evidence of them. Because on the earlier occasion, the police have been visiting my house and disturbing the wife of the petitioner number 1, that is the mother of the petitioner 2 and 3, and on a regular basis. So I'm asking for an interim. Interim may be granted. I will appear before the police officials. Will appear before the police officials and provide our statements. We'll cooperate with them.
Satgaon, Malad may fix on next Thursday, 6. I'll produce the CD without in the Malad. On 6.
Interim may be granted. Yes. They've accused us of stealing gas cylinders of 47 number gas cylinders in one single day. It is not possible, and we worked there. The petitioner number 1 and 2 only worked there. He was just implicated just because he is the son. He was implicated in this FIR. Kindly interim may be granted.
Whose wife is sick?
Petitioner number 1. There is a mother of petitioner number 2 and 3.
2 and 3 are the son of
Sons.
number 1.
Were the FIR named accused?
FIR name accused all were named there, but the third person name was Farooq Ahmed, which ought to have been.
All of you are working there.
No, the third person was a minor child. He was not working there. He's a student. He was studying. I have also an school leaving certificate also there at page 25. Transfer certificates. The FIR, his name was given as Farooq Ahmed, but his real name is Syed Rich Ahmed. I have also annexed other documents also in his name. Police are already have searched everything. They have came to my house. They have searched thoroughly, and they have seized only one cell phone. That is also the mother's cell phone.
It was earlier rejected after
Yes.
perusal of CD.
Kindly, yeah.
So and
They may be given.
she did not receive list again on when? Monday? Huh?
No,
Thursday.
6.
Point out the earlier rejection first, then we do not take so much time.
Please, Lordship.
No. CD not yet received, my lord.
Earlier PCA.
Can copy, I think.
No,
Can-
not charge sheeted case, my lord.
No, substituted.
Not
38.
38.
38. Substitute submitted.
Can copy was called.
Scan copy was called for.
Is
Can
there.
receive, regarding
Scan copy is there.
Lordship.
Scan copy is available regarding service, my lord. Service is not yet. Substituted on 14/6. ORP PS 10926. No?
But a POXO matter.
Also 6.
So, POCSO. Only I'll take instruction regarding service of notice, my lord. Fine.
There is a 183 statement is not there. Why has it been said? What will you do with all this? If the statement of the victim itself is not there.
Sometimes it is kept in envelope, seal envelope, and the peons might have not have scanned it. Then it may be mentioned that this will. In the meantime, I will take instruction regarding service.
Otherwise, police statement implication is there. Our learned counsel for the petitioner and learned additional PP. Scanned copy of the TCR has been received without the statement of the victim recorded under 183, section 183 BNSS.
Medical report also, my lord.
Report is also not available. Learned court below is directed to take due care, see that the entire record is sent. The next date fixed. Entire record, including the statement of the victim recorded by the magistrate as well as the medical report. Next date fixed. Also notice to the is the matter again on
13. Nine, 40, 41, and 45 out of same affair, madam. 39
together.
40, 41, and 45, madam. Earlier,
Injury report is available now.
Injury report is there, madam, yes. And now, madam, injury report several person, madam. First one is in scalp, but simple. Second is simple by blunt. Third is simple by blunt. Simple by blunt. Is simple injury. Is grievous by blunt.
Grievous?
Grievous by blunt. And grievous by blunt. But it is not given. Grievous by blunt or simple injury, that is given. Several person, otherwise injuries by 8%. So 109 is there.
Yes.
And As far as statement of the main victim, victim, he is the he was referred to GMCH from Borpeta. Otherwise treated at Borpeta itself. More জখম বেশি হওয়ার and that he is grievous by blunt.
Item 1325.
Earlier, 118, 2 will not come now. 2 is grievous injury. Earlier 326.
FIR on page 13, Lordship. Mary, mention be made that about 3-4 years ago, the informant's brother-in-law Baharul.
All right, heard learned counsel for the petitioner and learned additional PP. This is an application under so and so. The brief of the case is that page 18. First, what is this item? 39.
39.
The CD as called for has been received along with the injury report. The injury report reflects simple injuries except cases of previous injuries caused by blunt object. It prima facie appears that section 118 within bracket 2 BNS may not be attracted. Having regard to the material record, prayer for pre-arrest bail is allowed. The prisoner so and so in the event of their arrest connection with so and so case shall be released on bail of rupees 20,000 with the CRT each for like amount to the satisfaction of the arresting authority. Further provided that the petitioners shall cooperate the investigation and appear before the IDO within a period of 10 days from today. It is further provided that the petitioner shall not attempt to intimidate the victims or the witnesses of the case in any manner. Petition stands allowed accordingly. 39, 40, 41 and
45.
I have Lordship, I have for the 40, 41 and 45 Lordship.
yes.
Certainly, Lordship, and there the cross FIR is also there, Lordship, and we have filed one FIR.
All are arising from the same affair.
Same FIR, Lordship.
You are not happy with this order.
Lordship,
You are not happy with this order
I have
being applicable to all of you.
Lordship. Obliged, Lordship, deeply obliged.
Forty-two, CB not yet received. Service notice also.
Lordship, petitioner number 2 and 3 is on internet and petitioner number 1 is not, Lordship. FIR is at page 14, Lordship. Lordship, this FIR is totally false and fabricated one, Lordship, and the entire fact is that
Service notice also required.
the accused person kindly come to page, Lordship, 24, Lordship.
Detailed order was passed after hearing you, so
Yes, Lordship.
we'll wait, have to wait.
POCSO,
Come to a different finding on every other day. They did not received a notice on respondent number 2 is also not it. List again on so and so interim order passed earlier to continue till the date of listing.
12, 12. 43, 44 my lord, my learned friend has gone through my lord, my Konkon Das my lord, maybe after some time my lord.
My lord, in this case, they are all entering, my lord.
After some time, let him come.
Time, my lord.
Yes, next.
Yes, this is a lot. But 483 application. In this case, my lord, POXO is there, my lord, and on last occasion, lordship directed to be to reflect the name of Mr. M.S. Brown, my lord, for amicus. And CD was there, my lord, as per earlier order dated 22/7/2026. In respect of Kajalgaon PS case number 40/26, in which we are seeking, my lord, pre-arrest bail. There are two cases, my lord.
In this case, scan TCR?
Scan TCR in respect of the case which has been filed by the petitioner's family, my lord, has already been received.
CD not received, my lord.
CD,
This record pertains to earlier affair.
yes, my lord. The affair which we have filed, my lord. The petitioner's family filed first in point of time that resulted into charge, PRC case number that has been received by the registry, my lord. And as per my lord, and in respect of the present case, my lord, this 40/26, the order dated 22/7/2026 reflects that case diary was available, my lord.
Yes.
But,
It was
perhaps my lord, the scan copy has been shown, my lord, perhaps by mistake by our office staff also, my lord.
It is searched.
Succeeded by the cross case
Cross-case
succeeded.
yes.
Because of that, my lord, scan TCR is mentioned in the, my lord, maybe some.
All right, scan
And
code.
Services, MK Brown's name was directly.
Amicus maybe.
Amicus already appointed,
It's
my lord.
already there.
Only her name has not been reflected today, ma'am.
She was here. Is she aware? Just now she was here, I think. I thought she had come for this case. And copy of the PCR of PRC case number 62/26 arising out of Kajalgaon PS case number 35/26 is available, but ID of the present case not available. Although it is reflected in the order dated 22/07/26 that the same is available. Has it gone back or is it there in your office somewhere?
I'll fix that too. My learned senior can take instruction to that respect, madam.
What about amicus? Name is not there. Name of amicus is also not
Maybe fix on Tuesday.
reflected in the cause list. Hence list the matter again on Tuesday. Okay. Showing the name of S.M.K. Brown as amicus. And full stop it. Also to inquire regarding the whereabouts of the same. If it is not available, call.
Well, we'll call back.
4th of August, madam. 4th of August, madam. Lodge. Please.
Please, Lordship. Lordship, I have filed an
Yeah.
affidavit which is brought on record already.
So, matter will be taken after 2 p.m. Lordship. My senior counsel. 2 p.m. Lordship. And we have also filed an objection, Lordship. May kindly allow me to bring on record, Lordship.
What you have filed?
I have filed additional affidavit bringing all the, antecedents and all before this honorable court, which is on record itself, what I have learned.
It has come.
Yes, it has come.
And you have filed?
I have also filed a written objection, Lordship.
That is not here.
Not here, Lordship. Kindly allow me to.
After 2 p.m.
After 2 p.m. Obliged.
60 CD not received, my lord.
It was short that, my lord, no interim, my lord.
From Gorshuk, my lord, okay.
CD not received is taken on.
My lord.
My lord, can be on 4th of August, my lord.
No, no, fourth.
Goes to the nine, no?
On 6, my lord, 6.
6. God bless.
Service completed. Lordship.
Hmm?
Service completed. Lordship. Carrying on admission.
As per scan copies received. Service is complete and scan copy of the TCF has also been received. Is the matter for admission? Is on it.
This is an appeal against conviction, my lord. Under section 22C, my lord, commercial quantity. My lord, we have not received the objection, my lord. This is 10 years, my lord. So
Final.
We have not received.
we have not received the
Always
objection.
not filed, my lord. They fully.
They have not filed, my lord.
Section not yet filed by prosecution. But this is 10 years.
10 years.
10 years.
Additional PP press for further 2 weeks time to file objection. Is taken on.
Obliged, my lord.
Yes, somebody is appearing on. Petitioner in person is there.
Lordship, I am in item 48, Lordship.
Yes, this is 48.
Lordship.
Yes.
Lordship, on the last occasions, my lord had heard me in interlocutory application 1308, praying for vacating the ad interim stay. The respondents in IA 1308 had prayed for a short accommodation that was granted today. Now, my lords, my prayer for vacation is for a humble reason that an ad interim stay was granted without hearing us. The stay has lapsed in 2024 when the order was reserved. It did not come up for some reason. The hearing was conducted again from 25 to 26. Again, the order was reserved. And again, for some reason, it did not come up. So the ad interim order has already died a natural death, Lordship.
What is the date of that order?
Lordship, it's in the month of April 2024, Lordship, passed by Honorable Justice P.J. Saikia, Lordship. Uh, 2624, Lordship.
Passed in the IA or no, it was passed in the criminal petition.
Lordship, on 2/6/24, Lordship.
Two, 6/24.
Lordship.
I think 21/6.
Lordship, I beg indulgence. There is something. It was that. I apologize.
Who is appearing?
Lordship, Mr. M. Basumatari is the advocate on record, and I had informed him of the matter being taken up today. He is before this court now, Lordship.
He's about to come through visit.
Huh?
He was supposed to come through visit from Arunachal Pradesh.
Call him up. Where is he?
He did not attend.
Is he linked to Pune Nigama? All right, call up the next item. In the meantime, sort it out.
Lordship.
Starting item 6.
May I please, as a lordship? My lord, this is a matter relates to Jimma of a vehicle, my lord, which had been seized for the purpose of, my lord, cattle transportation. My lord may be pleased to find the impugned judgment is at page 31, my lord. Lord, arising out of the original order, my lord, original order is by the learned subdivisional judicial magistrate is at page 27, annexure 2, my lord. The Jimma had been rejected, my lord, is at page 28 on the basis of aforesaid report submitted by the IO.
Which page are you on?
My lord, I am reading page 28, my lord.
Yes.
So make the issues short, my lord.
Yes, yes.
Page before this court not to release the said vehicle in custody of the Jimma petitioner. Seen the report, heard both sides on the basis of aforesaid report submitted by the IO and to cause any hindrance to the investigation of this case. The Jimma petition filed by the petitioner MD Rafiqul Islam stands rejected. The Jimma petition number so and so is accordingly disposed of. Again, this order, my lord, we preferred an appeal before the learned, my lord, session judge. Additional session judge take up the matter, my lord, and finally the judgment had been delivered at page 31. My lord.
Yes. So what happened?
My lord, in the impugned judgment, my lord may be pleased to find the operative part, my lord. My lord, may I read from page 33, my lord? Page 33, paragraph 5, my lord, the learned, my lord, quote below, taken up the issue of section 11, subsection 11 of the Assam Cattle Preservation Act 2021, provides that no person and his/her family members against whom a case.
So it is in your favor.
My lord.
It is in your favor.
My lord, it is in my favor, but my lord, the problem is that, my lord may kindly peruse the operative part of the order is at page 36. In view of the above, I find erroneous in the impugned or I find erroneousness in the impugned order dated for which the impugned order is liable to be served. Accordingly, the appeal stands allowed and the impugned order is set aside. It is hereby directed that the seized vehicle be released on Jimma of the appellant on furnishing a bank guarantee of rupees 10 lakhs. My lord, there is no any such provision. Not for the purpose of such, my lord, huge amount of bank guarantee, my lord. Now, my lord, I am not a person that such a bank guarantee can be extended or executed. And in the rules, my lord, the Act of 2011, the cattle section 11, my lord, has also does not, no, cattle too.
The law does not mention bank guarantee or anything. It's only suitable conditions.
My lord, that suitable condition is too harsh, my lord, for me. That is only my case, my lord.
What is your vehicle?
Vehicle is, my lord, is a truck, my lord. I have given the description, my lord, may be pleased to find.
Where is the RC?
Yes, yes, my lord. There memo from my lord may be pleased to find. My lord, what has happened? The registration card is also, my lord, in the custody of the my lord, investigating authority. That's why, my lord, we could not. But from the seizure memo, my lord may be pleased to find at page 24, my lord. One 12-wheeler truck bearing registration number, owner namely Full Mohammed, chassis number so and so. Make it.
Is the right track required to be produced actually at the time of sections are there in Ambalal Desai. You can take photographs and from different angles.
Pleaded the Ambalal Desai's case also, my lord, in the petition. Page 16, my lord.
So what are you willing to give?
Lord, my lord, reasonable, my lord, 10 lakhs bank guarantee, my lord. Even he cannot, my lord, cooperate with me.
Will you concede to photographs of the vehicle being treated as primary evidence in the trials?
Lord, that instruction I do not have, but my lord, as the vehicle has been seized, my lord. Now, that vehicle is a subject matter of investigation, my lord, that I cannot deny. And the seized property is also from the vehicle, my lord. That is an issue. But I am not the business, my lord, dealing with this cattle. Only it had been transported, my lord. Some security or, my lord, some that, my lord, undertaking that I will produce whenever required, my lord.
You have the judgment of Ambalal Desai?
Yes, yes, my lord. Yes, my lord can put on it.
এইটো লওক পইচা দা
Para 713. Paragraph 7 is also, my lord, relevant. Then
So instead of bank guarantee, what are you willing to execute?
not any local surety, my lord. Any local surety.
Bank guarantee as per the act, bank guarantee is, has to be given, madam.
As per the act.
Which act? Cattle. No, no. Lord, even we have gone through the act, section 11, subsection 11 of this Cattle Preservation Act is also not applicable in my case, but they have done the seizure in respect of subsection 11 of section 11, my lord. That may also be verified, my lord.
Yes, Malad, section 11.5, Malad, I am reading, Malad. On receipt of the report, the judicial magistrate first class may, on his being satisfied that there is enough material to presume that the prima facie offence under this section has been committed or intended to commit, release the seized materials, including vehicle, convenience, except cattle. Cattle is, there is a bar. On furnishing bank guarantee, equal value of the material or the vehicle convenience. Vehicle, then it will be, Malad,
Specifically there.
and
now-
equal value of a truck, Malad, it will be around more than 20 lakh,
Now-
30 lakh.
No, my lord, this subsection 11, basing on which this seizure has been made, my lord, the petitioner was, as per subsection 3 of section 11 is required, my lord, or under the subsection 14 or section 7 of the Cattle Preservation Act 2021. Rather, it was seized as per under subsection 11 of section 11 of the aforesaid act. Now, my lord may be pleased to peruse subsection 11. I am reading, my lord.
The case is under the Cattle Preservation Act.
My lord, cattle has been seized from the vehicle, my lord. That I am
So
not
your
denying.
vehicle is involved there.
My lord.
So what other case has it been seized? It is seized in connection with this case only.
Correct, my lord. Correct.
So why would that section not be attracted?
My lord, we have written in page 15, my lord, if just for a moment, my lord, may be pleased to peruse this paragraph. my lord. However, the learned additional session judge, North Lakhimpur, made a misinterpretation error by invoking subsection 5 of section 11 of the aforesaid Act of 2021 for allowing to release the vehicle of the petitioner on furnishing a bank guarantee equal to the value of the vehicle oblique convenience. Pertinent to mention herein that, as can be inferred from subsection 4 of section 11 of the Act of 2021, the police officer should report about the seizure before the judicial magistrate first class if any materials or carcasses or vehicle is seized only under subsection 3 of section 11 or under subsection 14 of section 7 of the Act of 2021. and only then the judicial magistrate first class, after receipt of such report, on being satisfied, may allow for releasing the seized vehicle except cattle on furnishing a bank guarantee equal to the value of the material or vehicle convenience to the satisfaction of the court. However, as can be inferred from the aforementioned provision of the ASA, subsection 5 of section 11 does not come into effect if any attachment or seizure is made under subsection 11 of section 11 of the Act. The aforesaid Act of 2021 is silent regarding disposal of any property or vehicle seized under. Milord, may I pray, Milord, this matter may be taken up on Monday, Milord. I will clarify on this issue, Milord. Today I am a little bit underprepared, Milord.
Third learned counsel for the petitioner and learned additional PP. The matter involves interpretation of the provisions of
Section 5, Milord.
Section 5 of the Assam Cattle Preservation Act. No. Seeks further time to address the court on this point. Is the matter again on.
Obliged, Milord.
Yeah, please, Your Lordship. Also, here is a state appeal, my lord, against acquittal. There is a delay, my lord. In the delay, but it is my understanding appear for the and file his objection.
What is the delay? 188.
188 days, my lord. Delay may be condoned, my lord, at this stage.
The appellant side have failed to explain any definite reason for such delay. Paragraph number 3 of their application. May I please read, ma'am?
Yes.
In paragraph number 3 of their application, thereafter forwarded the case record to the learned public prosecutor on 30/06/2025. Thereafter, discussion was going on regarding the case, and finally the records were disbursed by record room on 14/07/2025, and thereafter there were discussion till 22/08/2025.
Only, my lord, what happened before filing, my lord, the file moves through several offices, my lord. Therefore, it comes to us.
There is a proper lack of But if you go to the judgment part,
Was opinion of valor taken for filing the law department?
Yes, my
Is
lord.
there?
Yes, after that, it come to our office, my lord.
You mentioned that time. You said only discussion.
Yes, in the, my lord, yes. Certified copy we have received from the, my lord, Home and Political Department. Certified copy, after, my lord, authorization, my lord, the certified copy was received from the Home and Political Department. Thereafter, the case has been prepared and drafted and filed. A humble submission in the interest of the state, my lord, also may kindly allow us. petition, my lord.
Allowed, my lord, it will be a wastage of valuable time of this honorable court because there is no evidence against me. I am the husband of the victim and there is no statement made by the victim against me. I have a child as well, Your Honor. That part is already reflected in the judgment itself.
Where is the opinion of LR is there with you?
No, my lord, it is not in the, not here, my lord.
Hmm?
It is not here, my lord. But comes through a board, my lord. The board takes the decision and thereafter it was.
No, if you want us to entertain, you have to. You can't simply say that from this to that, there was discussion. End of the matter. No. So how it has moved. Where is the judgment?
My lord. Not listed first, my lord.
I have a copy of the judgment.
Advert copy is there, my lord. Okay.
Is the wife. There is no birth certificate in evidence.
Yes.
There is no oral evidence regarding her age. No knowledge.
Yes.
Victim herself says she is married to
Yes.
her and that she was above 18 years old at the time of marriage.
It may be taken up at the time of my lord, hearing the my lord lip petition, my lord.
And see this also, Supreme Court has said that
My-
merit can also be looked into whether not condoning the delay will cause any manifest injustice. But here from it, it appears that condoning the delay will cause injustice.
I have also referred to one of the judgments. Paragraph number 9, page number 4.
Yes, my lord. This case has been filed by my lord PP Dipto Prasad Goswami, my lord. Can it be taken up some other day, my lord? He will address it.
I don't want to read all these things once again. I'll take it up at 2 information.
Lordship, lordship. Lordship.
Sorry to interrupt, Lordship. Item 53, Lordship, hearing matter, Lordship. Today, senior counsel have some difficulties, Lordship. This matter may be posted at 25/8, Lordship. I am mentioning with the consent of other side, Lordship. Hi, Lord.
Yes, I'm,
What was this?
Lordship, this is arising out of the Bhoginity PS space 61 of 2026, registered under 329(3), 294, 74, 1172. My lord, in this case, except 74 other available. My lord.
Except?
74, my lord. 74 is non-available. Others are. Find the affair at page 16. Sir, I am for.
For?
Taking up 43.
Yes, this is 43.
He's for 44.
Huh?
Same affair.
Same affair arising out of. And the learned friend is submitting in 44.
You're submitting in? No, who is for 43?
I'm for 43.
Yes.
So here in this case, Lordship, the petitioner already granted bail, Lordship. They appeared before the IO and recorded their statement. Lordship, your Lordship will find the affair is at page 9. Here the allegation is hurt, Lordship, and molestation, Lordship. And because there is a public gathering, Lordship, the informal Lordship started construction on a land beside a graveyard, Lordship. And the villagers, Lordship, gathered there and resulting some quarrel, Lordship, between the villagers and the husband and informant, Lordship. And this affair is a outburst to that incident, Lordship. Because they started construction on a government land, Lordship, near the graveyard.
Have they appeared?
Last date of the CD is 19/6/2026. And interim granted on
In my
15/7.
16/7 in
But I
my
have not found their statements, Lordship.
they appeared.
Their statements are not there. It is on 19/6/2026.
When did you appear? When did you appear?
They appeared, Lordship, immediately within 7 days, Lordship. The exact date I cannot, but they have appeared, Lordship.
In my case, my lord, on is 26, my lord, and appeared on 29, my lord.
There is 19/6, which statements are not available, Lordship.
Forget their statements. Your statement, what is the other material is?
Other materials is there, Lordship. It is true that their shop is standing at a government land, Lordship. And beside that, according to the people, Lordship, there is a cremation ground for missing people. Their altercation took place between these two sides, Lordship. And it is stated by the police, Lordship, in the IO note that her clothes were torn. And moreover, the one white color shirt with black color strip is also torn. That is of husband, Lordship. So, and I have also the injury report of the both persons, Lordship. It is simple injury is there.
Because from their shop,
Otherwise,
Lordship, they
an
were
incident took place. That is, that can be ascertained, Lordship. The incident took place. The fight has been there.
because they started, Lordship, selling out some liquor from that shop, Lordship, and villagers objected to that construction and selling of, Lordship, alcohol, Lordship. Resulting some quarrel between them.
However, in the city, they tried to expand their shop in the backside of the cremation. That is
for construction at dhaba on the cremation ground, Lordship.
Very good. Item 44 of order dated 26/6/26, first para, second para, third para. The CD as called for has been received. The injury report only indicates simple injuries. Regard to the nature of the allegations and the available in the CD, the prayer for pre-arrest bail is allowed. Of entering the dated 26/6/26 is made absolute sense allowed. Same order.
Highly offensive.
Statements not recorded in this. Statements have not been found.
One line at additional PP submits that the CD, the last date of entry in the CD is 19/6, and therefore the statements of the accused petitioners are not available therein since the interim orders were passed by this court. Subsequently, alternate counsel for the petitioner submits that pursuant to the interim order, the petitioner has appeared before the IO and his statement has also been recorded.
In both the cases, Lordship, interim order are different date, Lordship. In my case, interim order date is 16
That
7.
interim.
That also I have not found out.
I need of it. I need.
My lord.
That is Lordship. Lordship, anticipated bail applications, my lord. CD is received. And may I submit, my lord? My lord, what has happened, my lord? The businessman. He operates in the state of Odisha. While he came in contact with the informant in the year 2014-2015. And the informant is a history sheeter. He defrauded him. He took some money, luring that he would hand over certain properties. This way, he took the money from the petitioner. Later on, what happened? The petitioner did not get the property, neither the money back, my lord. Then what happened, my lord? The informant moved to the state of Assam. He came in contact with one Mr. Diganto Chetia. He entered into a business agreement. Some disputes took place between them of civil nature. Then the petitioner, the informant, has been booked in one of the matters, one of the case which has been lodged against him in Odisha by some other person. And while he was in custody, I mean, that Diganto Chetia has filed a title suit for declaring their agreement void, my lord. Now, while he came out of the jail, out of the vendetta, out of the revenge, he lodged an FIR against Mr. Diganto Chetia. While filing FIR against Mr. Diganto Chetia, the sole FIR named accused, he has dragged all those persons who have lodged complaint or FIR against him in the state of Odisha also. These persons whom he dragged in the complaint, my lord, they are not interconnected, my lord. Diganto Chetia is a business partner of the informant in the state of Assam. And that person, Samir Patnaik, before my lord, he is a businessman in the state of Odisha, my lord. Now, if my lord may take up the FIR, my lord, it's a long FIR and my lord have gone through this FIR multiple times because two other co-accused has also been granted bail by my lord. FIR at page number, starts at page number 17, my lord.
17.
17.
Let's page 19 is the effective material.
Yes, my lord. May I take you to the, page 17 once, my lord. Here, my lord, at column 7, the sole accused is Diganto Chetia. Now, my lord, may go to the complaint, which starts at page number 19. And it's a very long FIR. If my lord allow, then I will go paragraph by paragraph, my lord. There are allegations against the petitioner, my lord, but there is nothing in the FIR or complaint, my lord, which shows that he has received any money. The money which he alleged either went to the account of Revoltix, which is, another person who is a victim of the informant, or it has gone to another person, Sunil Chahu, or his own company, Global Trading Company, my lord. So there is nothing that entered into the bank accounts of the petitioner, my lord. The second thing, my lord, the main allegations, which is at page number 21, my lord may see.
Page
21, my lord, last paragraph on 6/5/2025. My lord got it? At about 9:30 AM, I, along with Pranab Roy and Prashant Kumar Singh went to the house of Diganta Chetia and requested him to pay the misappropriate amount from me and my company. Hearing all this, the said Diganta Chetia abused me and other two persons by using filthy and unparliamentary languages. And when object, the Diganta Chetia has informed that Samir Patnaik, Nirup Sundar Chaudhary, Sabitri Chaudhary has misappropriated the said amount and threatened me that in future, if I came to his house, he shoot me and my family. And further, the Diganta Chetia came towards me and my partners who are along with me at that time with a sharp dao. Having no any alternative, we ran away from the house of Diganta Chetia. Due to such reason, we have saved our life from unwanted situations. My lord, kindly note the date, 6/5/2025. The focal incidents, my lord. And the FIR is lodged, complaint is made at page number 19, my lord may find, at 12/7/2025. That is 2 months after the alleged incidents, my lord.
Yes.
So, my lord, if my lord may take cue from this, the incidents which happened of the informant with the Diganta Chetia, it happened 2 months prior to the complaint. And if we take into considerations the allegations which he is bringing against the petitioner, my lord, then it is way back, my lord. If any misappropriations, if anything took place, my lord, complaint can be made at that point of time. So it shows, my lord, the petitioner informant has made these allegations, has brought this FIR out of his vengeance, my lord. Now, my lord, may see at page number 22. Starts at page number 22. Actually, it's an NI case, my lord, which has been, the plaint is at page number 28. Which is
Yes.
Petitioner had made case against the informant in the state of Odisha for a check bounce matter, my lord. And that matter took place in the year 2014-2016, my lord, which is, I mean, which can be reflected, which can be perused from the bail order which has been rejected, my lord, of the informant at page number 41. Page starts at 39. My lord, may take page number 41.
Yes.
The last paragraph. It's a bail order actually arising out of that NI Act case, my lord.
Yes.
From the record, it appears the informant is the proprietor of Messrs. Orion Minerals. The petitioner is having real estate business in the name and style of Messrs. Flogen Estates and Developers Private Limited. The petitioner gave the informant a proposal to invest money, and in return, they will provide him suitable landed property with building. With that belief, the informant had paid rupees 2.3 crore rupees to the petitioner company in between 2014 and 2016. Due to his engagements in business, he could not contact the petitioner. In the year 2018, when he tried to contact the petitioner, his phone was switched off. Then the informant contacted her wife, who told the informant that since a criminal case has been initiated against them, he should wait for some time to get back the money. In that process, the petitioner has cheated the informant to the tune of rupees 2.32 crore rupees. From the record, it further appears during investigation, the entire amount of rupees 2 crore, which was transferred to the account of the petitioner, is established. It further appears in the earlier occasion, the petitioner is also involved in EOW PS case number 6 of 2018 in loan fraud case amounting to rupees 4.32 crores. It further appears after lodging of this FIR, the petitioner had issued check to the informant, but it got dishonored. Accordingly, a complaint case under section 139 of NI Act, White so and so, has been initiated against the petitioner. Investigation of the case is still in progress. Thus, having heard the learned counsels for the parties, taking into consideration of the above facts and circumstances of the case and the amount involved, this court does not incline to release the petitioner on bail. Accordingly, the prayer for bail stands rejected. My lord, it shows that that dispute is of 2014-2016, my lord. And when it has come to the knowledge of the instant petitioner, my lord, he has lost a case. And that material has been found by the Honorable Court of JMFC Bhubaneswar, my lord. It is on the record. And while, I mean, the petitioner, it is mentioned in the bail order itself, my lord, while the petitioner tried to contact with the informant of that case, my lord, at that time also the informant was behind bar. So, I mean, he is a history cheater, my lord. He has cheated multiple persons, my lord. And every occasions, I mean, while he cheated someone, my lord, he made a counter blast, my lord. In earlier occasions also, my lord, has granted bail to two other persons, one Diganta Chetia and one Savitri Chaudhary, my lord. They were also, I mean, implicated by in a similar fashion, my lord. So it is a clandestine manner. In this manner, the petitioner, the informant tried to get away from the clutch of the judicial administrations, my lord.
Yes.
My lord may subsequently find at page number 44, the prime accused has been granted bail by my lord on 14/11/2025. It was an interim bail. Subsequently, that bail was made absolute, my lord.
Yes.
Then my lord may also find at page number 50,
Yes, who is this?
this is one of the co-accused, my lord, whom my lord has granted bail on 17/6/2026, my lord.
Yes.
In this order, one important observation has been recorded by my lord at para 10. My lord got it.
Yes.
Para 10 at page number 54. It also appears on perusal of the case diary that the investigations of the case has been completed, and the Circle Inspector Shimalguri Circle Shipsagar, by submitting a final progress report of the case dated so and so, has suggested the IO to submit the charge sheet. So it shows, my lord, the investigation has been completed. And now the police is behind me, my lord. They are threatening me, my lord. At the one hand, they are threatening me. On the other hand, my lord, the informant has been trying, because he is in custody. He is trying to get away, and he is pressurizing me that, I mean, come to a compromise. Otherwise, I would not, I mean, spare you. So, I mean, this is complete abuse of process, my lord. And my lord, regarding the antecedents which has brought to the knowledge of my lord, I have filed an additional affidavit in that regard.
Antecedents of the informant.
I mean, there are antecedents of the informant I have not brought, because, I mean, it has not in complete knowledge of me, my lord. There are a lot of cases. He is still behind bar, my lord. Today was, I mean, there was a hearing in Odisha High Court also. Today was a hearing, but I mean, it was deferred to 24th of August, my lord. Now, I have brought the antecedents of the, I mean, petitioner, my lord. He is a businessman. Some business rivalry are there, my lord. Some civil disputes which has been given, I mean, color of a criminal nature, my lord. There are 8 pending cases, my lord. And in all of the cases, the petitioner has been granted bail, my lord. And in number of judgments, Supreme Court has made it very clear, my lord, that the antecedent cannot be a ground to deny bail, my lord. A bail application should be considered on the merits of the case, my lord. I may produce certain judgments also, my lord. Regarding, I mean, I have perused the learned counsel on the other side have filed an interlocutory applications for impleadment. At the same time, he has also given a list of cases against me, my lord. He has brought to the knowledge of this honorable court that there are 11 cases pending against me. But my lord, I have the closure report, 4 cases, my lord. In 3 of them, I mean, in final report, the matter has been closed. And in 1 cases, charges have been framed, but my name has been dropped. And I have all these documents, my lord. I may produce it with the leave of this honorable court, my lord. So this is the submissions, my lord, that criminal antecedents, I mean, these are just, I mean, business rivalry, out of business rivalry, certain cases have been filed. That cannot, I mean, vitiate my case before my lord, my lord. The complete case is a complete, I mean, frivolous case, my lord. And the informant has tried to settle the score, my lord. There is nothing else. So considering all this, my lord, with reserving my right to, I mean, respond if the learned counsel on the other side submits with the leave of this honorable court. And with this, my lord, I'm praying for anticipated bail of the petitioner, my lord, because on all parameters, my lord, he is ready to cooperate with the investigations. He is a patient, my lord. He is of 57 years of age, stays in the state of Odisha, my lord. Once, I mean, my lord grants him protections, my lord, he is ready to abide all the conditions which my lord may fit appropriate for in this instant matter, and cooperate with the investigations, cooperate with the trial, my lord.
Yes. My lords, first of all, this is an anticipatory bail application. Bail itself is not a matter of right. It is an equitable jurisdiction of the court. Court balances the interest of the estate as well as the interest of the individual, factoring in Article 21 and all. In anticipatory bail, minutes, considerations are entirely different. What are the considerations further? Well, first of all, he should have impleaded me also. Probably he didn't implead because the practice in this court was something different. So that I'm not harming. My lords have been kind enough to permit me to address the court, so I'm grateful. My lord, issue here is a person of the antecedents. He is calling the other side, me, as history sheeter. Whether I am not history sheeter or history sheeter, that is matter of investigation and fact. Point here is, he is himself admitting that there were 8 cases which is pending against him as on today, in which he is from bail from various courts, including the Honorable High Court of Odisha. In 4 cases, he has been granted bail, regular bail, not only anticipatory, regular bails also, against very heavy conditions. In 1 case, minutes, 3 crores cash deposit has to be maintained continuously with the trial court. In another case, 50 lakhs. So if there is anybody history sheeter, it is the petitioner. That apart, minutes, what is his conduct? In this case, when Assam police went to Odisha because he was not responding to the notices issued by them, he locked himself inside. His wife blocked the entry, jumped to the neighbor's house. Finally, the Odisha police has to approach the learned magistrate, take the requisite permission, and break open the door. This went for almost 4 hours. I will just refer to it. My lords can come to page 57 of the paper book. The order, the learned session judge, while rejecting the anticipatory bail, has referred to this, page 57 minutes. Because she must have studied the case
of your application.
The petitioner's petition. 57 minutes, last page. This is the bail application rejected by the learned session judge, district judge. At the end. Let's have it.
This is Sipsagar.
Yes, Millet. That is the learned district judge rejecting the same bail after the petitioner has.
Yes, I have gone through this.
Last paramilits. IO in his objection stated that the accused petitioner has not cooperated with the investigation of the case till date, and that he had fled from his residence, next page minutes, while attempting to apprehend him. IO has also stated that the accused may try to hamper or temper the investigation of the case if allowed to go on bail. Lord, here is a person who is claiming himself to be, paragon of virtue and innocent and all. Right or wrong, once the estate is seeking him,
The police officers are traveling all the way from Assam to his house because he is not joining investigation, he is not responding to their notices. He locks himself inside, hides behind his wife, a woman, jumps to the house of the neighbor, disappears. The local police had to intervene, the local court had to intervene, break open the door, only then his whereabouts are ascertained. Can such a person be trusted with anticipatory bail? Will he appear in the trial? Who will ensure? Can the Assam police, the Sivsagar police be able to ensure his presence before the trial court, which is mandatory? That is the first thing, Milord, regarding antecedents. And this is his conduct in this very case, which is before the learned district judge. The IO has submitted the objection. This must be part of the case diary minutes. Now, minutes, with due respect, Milord, what is the law regarding disclosure of complete factual background, antecedents included? So, Milords, very recent judgment, Milords, 11th of February, 2026, Jeba Khan versus State of UP and others. Milords can come to running page 43. Page 48 minutes. Para 48, sorry. Page 43 minutes, para 48. Second para from the top. Milords have it. Thus, this court is of the view that every petitioner or applicant seeking bail at any stage of proceeding, bail, Milords, not even anticipatory bail, is under an obligation to disclose all material particulars, including criminal antecedents and the existence of any coercive processes such as issuance of null bailable warrant, declaration as a proclaimed offender, or similar proceedings, duly supported by an affidavit so as to promote uniformity, transparency, and integrity in bail adjudications. In this case, bail petition has been rejected also. And then their lordships have prescribed complete format. And I'm told by my local associates that this Honorable High Court has issued a circular for this disclosure. Delhi High Court has issued a similar instruction. Supreme Court has issued a similar instruction. Registry is not accepting in those courts, Milord, if the antecedents affidavits are not enclosed. Here, Milord, there's not a word, single word, a whisper in the entire petition that he is having, at least according to him, only 8 cases pending. These disclosures come only when we appear before my lord, seek the indulgence of the court, and start assisting this honorable court. Only then they are coming with an additional affidavit. My lord, no such disclosure was made before the learned district judge Sivsagar. That shows the malafide, that shows the dishonest intent of this particular person. They didn't disclose anything to the learned district judge. District judge is also very, high in the hierarchy, Milord, just below the Honorable High Court. So concealing material information before the Court of Sessions, then concealing material information before this Honorable Court, and then coming out, not one word of explanation is there in his explanation, Milord, his additional affidavit, why this was not disclosed earlier. Munish Kumar. Anyway, I have quoted in my petition itself. The Millets can, there is another earlier also, Millets, in 2024, a division bench of Honorable Apex Court. Millets can see my additional affidavit or my running page 105, internal page, of course, the 105 running page. court file page number 105 minutes.
Yes.
6 minutes. That the present applicant also places reliance on the orders dated 3/4/2025 of the Honorable Supreme Court in the case of so-and-so, titled as Munesh versus State of UP, whereby the Honorable Apex Court dismissed the bail application with severe strictures inter alia for concealing the antecedents of the bail applicant from the Honorable Court and issued specific directions which are extracted here in below by the applicant. Next page, Millet, para 9 is important. Others, of course, are observations of the Honorable Court. Last, at the bottom of page 106 minutes. Be that as it may, since the petitioner has suppressed material facts with regard to his involvement in criminal cases, he is not entitled to the discretionary relief of bail. Even otherwise, the trial has progressed reasonably and hence no case for releasing the petitioner on bail has been set up. In this case, Honorable Allahabad High Court also rejected the bail on this ground itself. Then against that, they came to Honorable Supreme Court, where the Supreme Court has in fact observed that we would not have even issued the notice had we been aware of this suppression of the antecedents. So let's the Honorable Apex Court and this Honorable Court also takes very seriously, because anticipatory bail is a very strictly equitable jurisdiction. The court has to balance the interest of a private individual with the interest of the society. And it balance becomes sometimes very delicate. So Millets, in that case, concealing material information while calling other side to be history sheeter. Against me, he has mentioned only 2 cases. I am in custody because of 138 NI case. There is another dispute. He is admitting 8 cases. Now he is further, even in this additional affidavit, he is concealing Millets FIR. This is one FIR where the court itself directed registration of the FIRs. In fact, the complainant, it is the learned Moist JMFC Bhuneshwar, who is registered as complainant. Well, it's, of course, sections are cheating and forgery, etc. So if my lords can come to page 2 of the FIR, column 12. Next 3 minutes. On dated 1st of February 2024 at 2 p.m., IIC received the order from the Honorable Court of JMFCO complaint as it reveals a cognizable case under section 420, 467, 468, 471, 120B IPC and registered as case number so-and-so, so-and-so. And Millets, address, if the column 6 on page 1, Millets can see, the address is Office of the JMC First, O, Bhuneshwar, Badagad, UPD, Bhuneshwar, Odisha, India. Court records were tempered by him. And learned JMFC had to direct registration of the FIR. He is such kind of person who is not even sparing the court records. And this is, even now this has been concealed. And this is not the only case, Mills. And this investigation is going on, Mills. There is another case in which court has initiated 340 CRPC proceedings for filing a forged document for getting bail. That matter is also under investigation.
Yes.
So let's the Dalit Singh wala judgment book. Court ke liye. Let's the Honorable Supreme Court has been very categorical. Not now, much earlier.
Which part of this order you had just referred to, order of the magistrate Bhubaneswar?
See para 6.
Para?
Para 6, last column, Millard, address of the complainant. Last tabular. Address of the complainant, present address, Office of the JMFC so-and-so. And on the next page, Millard, page 2, permanent address, Office of the JMC. In fact, this complaint was forwarded by the Office of the Learned Judicial Magistrate First Class Bhuneshwar because of his conduct in the court. He has been filing fabricated forged securities in the court for securing bail. which was found out, and the court directed to register the FIR. So court staff has actually, JMFC does not have many staff, so one of the, reader or some might be. And this FIR has been concealed specifically. If my young brother can show it, I will withdraw minutes. The point here is he is misusing the indulgence of this honorable court. He is misusing the process of this honorable court, which is a constitutional court, millet's second highest court of the land. He is concealing even after getting a chance to make amends. He did not disclose anything, millets. There can be something that there are cases pending. We are collecting information. We will file in due course. Some sort of pleading should have been there. And it is his cases, not it is that cases filed against somebody else. So he must be knowing all those cases. And he's in bail in all these cases. So millets, he has deliberately concealed his antecedents, for which cases after cases the Honorable Apex Court is directing that a dishonest litigant has no right to get any equitable indulgence of the court. And not only in the bail cases, Miller, that is the general law also. I will invite my lord's attention to this judgment of 2009, Dalip Singh versus State of UP and others, where the Honorable Apex Court had deprecated the general conduct of dishonest litigants and has given a clear finding.
In this case also, he is on bail.
Most likely. That is what my lord told from Bhubaneswar.
I'm not interrupting, just adding that in this matter, charge sheet has been filed, my name has been dropped. That is why I have not incorporated this. If my lord requires, I will produce the charge sheet where my name has been dropped.
If the name has been dropped by the IO, that does not mean that I have got a clean sheet. The court can still summon me. Plus 319 is there. So millet, disclosure of information is to be honestly, it should not have been concealed. What my brother is saying, it could have been said in the additional affidavit that in this case, I was named accused. Investigation in the final report, I am not named. The charges have been framed against those named. Case is resting at that. This is the correct distinction. Concealing information, and this is not the only case. There are other cases I will show. So millet's point here is whether the conduct of the petitioner, applicant before this honorable court, inspires the confidence of this honorable court to consider equitable exercise of equitable jurisdiction to grant him anticipatory bail. And all the more when he has not cooperated with the investigation and there is no likelihood that he will cooperate with the trial. I don't want to use any harsh word against him. I have nothing personal. I'm an officer of the court. But very fact that he may be a businessman, 11 cases or 8 cases are still pending against him, admittedly. According to me, 12 cases. According to him, 8 cases. So 8 itself is a huge number. What kind of business is this that all over India is landing in criminal cases? And all similar nature, 420, 467, 471, 468, 463. That means he is habitually indulging in fabrication of the documents. And at least he's getting accused. Why? He's not the only businessman. So Millet, all this taken together, as far as other accused are concerned, Millet, their antecedents may be different. Court might have considered their case depending on the facts of that case. Parity, since parity is being claimed, parity cannot be claimed in this case by this particular applicant because there is no parity regarding antecedents, and that's why antecedents were concealed. Issue here is why the antecedents were not disclosed before the learned district judge, number one. And number two, when learned district judge was not persuaded, maybe for some other reasons, because learned district has no advantage of knowing his antecedents, so no findings have been given. But then, Millet, when they came before this honorable court, why the antecedents have been concealed from this honorable court? After 1.5 months or 1 month or something, when we appear before the court, we seek the leave of the court to assist my lords, then they are coming, that also part disclosure.
May I submit?
So can he be, I'm not finished, brother.
Yes, yes.
So can he be trusted? Now, Millets, the background of anticipatory bail, Millets, just few minutes. In CRPC of 1898, Millet, there was no anticipatory bail, there was no concept. In 1973, when the CRPC 1973 was being enacted, there was no provision for anticipatory bail. What we call anticipatory bail, my lords knows better than me, is basically an order to be released on bail in the event of arrest. It's a protection basically, not the bail per se, strictly speaking. So on the recommendations of the 41st Law Commission report, the government accepted the report of the Law Commission saying that there may be political vendetta, there may be some other, it was word used was political vendetta, not the personal rivalries and all this. So there may be a cases where because of the political considerations, people might be getting arrested. So courts must be having some discretion available to look into and take a call. So because of that, Section 430 was brought in, which has been retained in BNSS as 482 minutes.
Well, we have evolved since then. It was initially meant for the high and the mighty.
Yeah, now it has, courts have evolved, my lords.
Now even cow thieves are before us.
My lords, I mean, law is an evolving process. It is not nothing stagnant. It keeps evolving. While we are interacting, my lords, we are also thinking in our minds. So things will keep coming out, and that is what law should be, my lords, with due respect. So, my lord, what I am saying is that anticipatory bail cannot be, even bail cannot be claimed as a matter of right. We are arguing bails all over, every court. We can't claim it as a matter of right. We try to balance that the state's interest will not suffer, society will not suffer if I'm granted bail, or if I'm not at fault and trial is getting prolonged unnecessarily. Then in that case, even the stringent conditions of NDPS or PMLA or UAPA are being relaxed by the constitutional courts. K. Najib is the full bench judgment, K. Najib versus Union of India Millets, where the Honorable Apex Court has said that constitutional courts can enforce Article 21, even if the statute does not provide for the bail. So, Millet, all those things are there. My respectful submission is that whether the conduct of this, even in this petition, before this Honorable Court, apart from what is there earlier, he has not disclosed the full and correct fact, which is a mandatory precondition for consideration of any kind of protection by a bail court, Millets. That is what the two judgments which I have pointed out, and that is what the general law, Dalip Singh versus State of UP, is very clearly saying that a dishonest litigant has no right to get any relief from the court, much less equitable relief. So that is the case, Millets. Now, Millets, how Assam police will ensure that he will come and face the trial? His conduct is there. When Assam police gave notice, he didn't join. When they tried to arrest him, that too on the order of the court. Thereafter, this is the judgment of Munesh. But at the page 2, para 6, there is no disclosure in the special leave petition as regards the petitioner's criminal antecedents, which includes conviction in one case under Section 379 and 411 of IPC. We inquired from the learned counsel for the petitioner as to why there is no disclosure in the special leave petition about the petitioner's criminal history. He submits that the parocar of the petitioner did not provide complete information. Had the petitioner's criminal history been disclosed in the special leave petition, we wonder whether notice on it would have at all been issued. That is very serious observation by their lordships, and we all are bound by that. That if the antecedents had been disclosed that he has already been convicted in one case, that to 379 and 411, stealing and purchasing the stolen goods. Maximum sentence is 3 years for that. Then that their lordships are wondering whether they would have issued notice in the first place. Here is a case where there's a complete concealment, not single word, that he is having other cases pending against him in which he is named accused, he is facing trial, he is on bail, at least 7-8 cases from various courts right up to the Honorable High Court. He has not said anything that he ran away, he didn't respond to the police notices, didn't join investigation, ran away from his house, getting the house locked by his wife. Police had to approach the local magistrate. London magistrate had to issue necessary authorizations. The house was broken open, and then only probably they could find out that he has run away. So, can he be trusted Is he a person whose conduct inspires the confidence in the minds of an ordinary person, a layman on the street, that he should be protected by this honorable court? That is my question I'm asking to myself. My respectful submission is that in view of the law of the land as settled by the Honorable Apex Court, in view of his conduct, and in view of his conduct vis-a-vis the other accused, he is not entitled, he doesn't deserve the indulgence of this honorable court, the indulgence of the equitable jurisdiction of this honorable court. And this petition must be dismissed. He must be directed to surrender to the trial court. He can ask for regular bail. The trial court will examine all the factors, whether his presence is necessary or not necessary. At this stage, Miller, why he's asking anticipatory bail? Because, Miller, there are state amendments in most of the states where the police has to forward the accused along with the charge sheet. So police is now helpless. They tried once, they have failed. That's why he knows that now he will have to be arrested and produced before the trial court. He knows very well that his conduct is not that he will get the even regular bail easily or at least quickly. That's why concealing everything, at least his conduct in this particular case, concealing everything, painting himself to be an innocent person wronged by all the crooks of the society, as he is calling me, he is seeking the indulgence from this honorable court. In such a situation, Millets, he does not deserve. It must be dismissed with some heavy cost, with the direction to go and surrender the trial court and seek the remedy from the trial court, which is the first court, and which is the, provision of the law.
My lord, may I submit? My lord, at the very outset, the learned counsel on the other side submitting that I have concealed something. Had I been concealed, I would not have filed the additional affidavit. He has brought 11 cases. Out of them, 4 cases where already charged, either my name has been dropped from the charge sheet or either closed, my lord. Now I have given list of 8 cases, my lord. So there is no questions of suppressions, my lord. Second thing is the matter which is referring that, my lord, the judicial magistrate first class is directed to lodge FIR, my lord. This is the charge sheet, my lord. I may forward it to my lord for perusal. My name has been removed from here, my lord. It has been dropped against me. Now, if charges are not there against me, my lord, how can that be an incident, my lord, as antecedent, my lord? Now, second thing is regarding 3 other cases, my lord. Closure report has been submitted, my lord.
Well, just for the information of the court, I'm not countering him. All these issues in this Jeba Khan are there. Status of the case is a specific call. So, if the charge sheet has been filed, that can be shown. Trial is going on, that can be shown. If the accused has been discharged or is not named, whatever, it's Honorable Apex Court says that what is the status of the case. So all these things are part of the disclosure. He is not permitted by law to make presumption and assumptions about his innocence or guilt. Both. He may be guilty, may not be guilty. So he has to come with clean hands before the court, disclose, and let honorable court take a decision. Here issue is not that in disclosure is being made now. Why it is being made now? That is the question. Why it was not made before the learned district judge in the first place, and why it was not made in the application in the first place. After we appear and we point out, he says yes, and there is not a single word why it is being disclosed now, 1.5 months after the bail application is filed. Well, once the other side points out, we are an adversarial system, other side points out, obviously he is admitting that yes, that is there. But why didn't you disclose in the first instance when you sought the indulgence of this honorable court? That has to be answered.
My lord, may I submit, my lord? As the petition has been pending, my lord, so I have not lost my right to put before the, my lord. I have brought these records during the pendency of the matter, my lord. And while it has been moved before the court, trial court, my lord, that was very initial stage, my lord. Perhaps the advocates could not collect all the records, my lord. And as far as the disclosure of the 3 other, my lord, I have brought all these, closure, my lord. When the matter has been closed, now if someone has leveled against an allegation against me, out of thin air, can that be an antecedent, my lord? Now, the second thing is, my lord, as my learned senior is pointing out that 3 crore rupees, surety matter. They have approached the Supreme Court. Supreme Court had dismissed their special leave petition, my lord, and I have complied with this condition also, my lord. He is talking about my conduct, my lord. These 8 cases where I am enjoying bail, I am on bail, my lord. I mean, this shows that I am cooperating with all the cases, my lord. In all the matters, I have been appearing, my lord. Now a matter has been, I mean, he has done it because he knows to harass the person, he has to file a case in Assam. Now both the person in the state of Odisha, they operates in the state of Odisha, all the transactions took place in the state of Odisha. Why he, I mean, file a case in the state of Assam? Just to harass me, my lord. Just to, I mean, make such anomalous things, my lord. Now the thing is, my lord, I am just seeking my lord's indulgence to submit me without interruptions, my lord.
A bail court cannot go into the, I'm sorry,
Go back and forth, please. Let him complete.
This much grace, my lord, I seek from my lord's indulgence. Highly obliged, my lord. Now, this regarding antecedent and all, my lord, I have come up with certain judgments, my lord. My lord may find Prabhakar Tiwari, the Honorable Apex Court, Para 7, perhaps, my lord. Listen. Para 7, my lord. May I read, my lord?
This is about, court said that the fact that cases are pending is not sufficient to
Yes,
deny.
my lord. Yes, my
This
lord.
is not about suppression.
Yes, I mean,
that is a different issue. That my lords are very correctly.
Antecedents cannot be a ground, my lord. I mean, I agree with my lord's observations, my lord. Antecedents cannot be a ground. I mean, he is taking the matter to the antecedents, my lord.
No,
Now,
no, no.
antecedents cannot be a
This is
ground
not
to
my-
deny bail, my lord.
With due respect, my young brother, what I am saying, my lord, is perfectly all right. That it is a final discussion rests with the honorable court. Antecedents has to be fully and truly disclosed so that court can apply its judicial mind and take a judicious considered view. Here is the case. What I am complaining against is the suppression of the antecedents, not the antecedents. I'm also not saying that just because antecedents is there, bail cannot be granted.
Because that sort could cut you too.
Mindless. That's always. But here the issue is nobody is allowed to conceal material facts from the court, and antecedents has been held to be a material fact. That is the case which my younger brother is probably slightly not able to distinguish.
My lord, I am truly agree with the learned senior counsel, my lord. The thing is, as the matter is pending, I have not lost my right, my lord, to disclose the things.
No, Millard. The petition has to be, Millard. Of course, CPC is not applicable here. The petition has to disclose in the first instance full and complete facts.
Had it been, my lord,
additional affidavits are filed because of some legal issue which may arise in the course of the adjudication or some other matter. Concealing material facts which are crucial for application of judicial mind, that cannot be cured on the ground that since case is pending, I still have my rights.
My lord.
Then what is the purpose of the affidavit? That's why the courts insist that every petition must be accompanied by an affidavit that there is a full, complete and truthful disclosure of the material facts. The affidavit becomes infructuous in that, redundant in that case, Millets. So what my brother is saying, Millet, that probably not help his case. He has to explain for what reason these particulars were not disclosed originally. It is only after when we have pointed out or objected or tried to bring before my lords that they are coming with the information. And my lord, that's why the saying that advocate may not be knowing, why to blame the advocate, my lord? We all are advocates. My lords, it is the client who has to inform his advocate about his complete particulars. If he does not inform, the advocate cannot cook up the information. So advocate cannot be blamed. And in any case,
not on that issue anyway. Nobody is blaming anybody in black robes.
My lord,
yes. My lords.
My lord,
grateful.
may I just take note of the, I mean, interlocutory applications filed by the opposite side, my lord. In the interlocutory applications, my lord, they have annexed the notifications. My lord, may I kindly peruse, I mean, they are interlocutory applications, this annexure D, my lord. But the things has been made clear, my lord. There is no preconditions that you have to file an antecedents prior, my lord. He stays in the state of Odisha, my lord. Lot cases are pending in different courts, my lord. It takes time to collect the informations, my lord. He is a patient, my lord. So these things has to be considered by my lord.
What annexure D page?
This is, I mean, page number, some discrepancy is there, but this is a notification issued by the Registrar General of this Honorable Court, my lord, where there is an amendment made to the, rule, Gauhati High Court rules, my lord. My lord, got it?
Yes.
In every application for bail presented to the High Court, the petitioner shall state whether similar application has or has not been made to the Supreme Court, and if made, shall state the result thereof. The petitioner applicant shall also mention whether he is involved in any other criminal cases or not. Correct. If yes, particular decision thereof, an application which does not contain this information shall be placed before this bench with the necessary information, my lord. My lord, that is why, my lord, now while the matter is pending, my lord, while before they have brought into the record, my lord, I have brought these things into record, my lord. How can that be a imputations upon me, my lord? And regarding the, my lord, the senior counsel has been submitted. My lord, another thing, senior counsel has been referring.
What is the meaning of this last line? An application which does not contain this information shall be placed before the bench
Yes,
with
my
the
lord.
necessary information. Who shall place the necessary information?
I mean, that slightly there's a problem with this, is my lord sir very correctly. In fact, this needs to be rectified by the Registrar General.
My lord, there is some discrepancy regarding this, but what I understood, my lord.
Okay, how the registry will know, my lords, what are the particulars? So they can
Yes.
only say that you file an affidavit that
Yes.
whatever you disclose is nothing.
That point may be clear, my lord.
Slightly wording of this, but my lord, in any case, the administrative instruction of the High Court issued on the administrative side by the Registrar General will not override, my lords, the judgment of the Honorable Apex Court. Article 141 is sovereign in that case, my lords. So, my lords, what the Honorable Apex Court has said on the judicial side will override all such instructions if there's any interpretation issue and all. The format which has been prescribed by in the Jeba Khan minutes, 11th February 2026, is very categorical. All situations are there. Even closed cases has to be disclosed. So that court can always formulate a judicial opinion that whether he should be granted bail or not.
My lord, even in Jeba Khan's judgment also, my lord, under para 50, the Honorable Supreme Court has not made it mandatory, my lord. They have asked to circulate it, my lord, and they have asked for, the High Courts may examine the feasibility of issuing appropriate administrative directions or incorporating suitable provisions in their respective rules consistent with their rulemaking powers. A copy of this judgment shall also be circulated to the district judiciary for guidance, my lord. So, my lord, this is upon this Honorable Court, my lord. And once that has been made mandatory, my lord, if any petition is missing with the antecedents at the very beginning, my lord, that would not have been admitted, my lord.
Well, there is no concept of counter rejoinder in bail. Otherwise, all these things will come up like a civil proceeding. But since my lord, Learned PP wants to address the court, so let's.
Regarding the fact that at that point of time, in March 2025, informant was in jail for 35 days. In the meantime, that accused person has sold a coal wreck amount to 1,74,000 and another 2,250 metric ton. That is also 1 crore 68 lakhs. Total 3 crore, more than 3 crore, 3 crore 2 lakh something. That is there. And
Who sold?
Petitioner.
This petitioner.
Petitioner. And by shooting at that point of time, using the machineries and all this of the informant. 35 days he was in jail. In that period, and subsequently, notice 35 notice regularly issuing by the authority and IO. He is not getting any hit to that, and subsequently when went to the Odisha, in his home, that with the help of the local police, he used to open the
Okay,
lock.
that's what we've heard.
Yes.
You second that.
All right. Notice, regularly notice has been issued and he is not having anything, otherwise, Lalit Senior has
Already passed on the CD.
I have taken
My lord, just one thing I may add, my lord. The submissions made by the learned VP, my lord. I mean, it is clearly written that they have sold one rack. I mean, he has not mentioned my name, amounting to rupees so and so. And from the said deal, my company, Global Trading Company, had received so and so, which was giving an advance, and the rest amount has transferred to Revolted Power Solutions Limited, which was.
What are you reading from?
My lord, from the FIR, page number 20.
Yes.
May I read, my lord? My lord, this is penultimate paragraph at page number 20. I mean, just referring the, affirmance which have made by the Lanet PP, that they sold one rack, one rack load amounting to rupees so and so, and from the said deal, my company, Messrs. Global Trading Company, had received only rupees so and so, which was giving in advance, and the rest amount of rupees auto has transferred to Revolted Power Solutions Private Limited in cash and through bank transfer instead of transfer to my company accounted fund, which my company owes for the aforesaid mining and other related activities. My lord, while after selling the rack, some amount has been given to his account, some amount given to has been transferred to some another person's account. How that can be put upon me, my lord? That culpability cannot be put on me. And if my lord peruse the whole FIR, whole complaint, my lord, in every occasions, my lord, there is not a single occasions where it is mentioned that some amount has been given to me, my lord. And my lord, one thing may just kindly note, my lord, all these persons, Shunil Sahu, Samir Patnayak, Diganta Chetia, all were in contact with the informant, my lord. They were not interconnected, my lord. So this FIR, actually, he has pointed it against Diganta Chetia. And while making the FIR against Diganta Chetia, he has dragged all the persons against whom he has, disputes. They are in the state of Odisha, my lord. So that is not sustainable in the eye of law, my lord. I am leaving it to my lord. And one thing, my learned senior has correctly said that, it is equitable jurisdiction and all. But my lord is also, aware that bail is a rule, jail is an exception, my lord. I am ready to cooperate with the investigations. I am ready to face the trial, my lord. There is not an instance that, my lord, bail was rejected by the trial court because this was an initial stage, my lord. Now almost 7-8 months have been elapsed, my lord.
But this is
From the
exactly the issue.
my lord,
How
just,
the trial court is
just
going to enforce
indulgence,
the
my
law.
lord. My lord, the matter has reached, the investigation has reached to an advanced stage, my lord. From the record itself, it reveals that the investigation is complete. Just to harass me, just to put me high, this is not the purpose of the criminal justice, my lord. To put me behind the bar.
Law is now the same. After the same law is very clear that if the person is not arrested during the investigation, court may release him on the bond. Section 88, now 91. So, Millets, all those options are before trial court. It's a question of anticipatory bail, Millard, with due respect. And Millard, that is the whole issue, as the state has also said, that despite repeated service of 35-3 notices, BNSS, he has not responded. He has not joined investigation. And when finally police went to his house, he disappeared, fled. My London magistrate had to get the house broken open. Lord, with that conduct, can he be trusted? Let him appear before the trial court. Magistrate may grant him bail on the same day, depending on the facts of the case. Anticipatory bail matter, can the evidence and entire, as if we are arguing the final argument in a criminal trial. All these, the other side wants the appreciation of the entire material evidence, etc., which even trial court will not do at this stage. This will only come up after 313 examination by the London magistrate.
No, he was responding to what was submitted by the PP.
Yeah, but that is a matter of evidence, Millard. How the evidence can be appreciated by that to a novel
No, don't blame him then.
My lord,
He should not have brought it
ultimately,
up.
my lord, I have to
Yes.
submit to court only, my lord, with due respect. Everybody is doing his bit. He's trying his best for his client. I appreciate that. As a young lawyer, he's doing his.
Yes, I think we have heard enough. Yes.
Just one thing, my lord.
Grateful.
At page number 97 of the additional affidavit, I have given the annexures of the medical certificates why I could not comply with the 35 notice. First thing is, I mean, I have some health related issues, my lord. Second thing is, my lord, this is the reasons why I am before my lord, my lord. If I appears and if they apprehends, I mean, what is the purpose of these anticipated bail applications, my lord? And regarding my conduct, my lord, I am appearing regularly before all the matters, my lord. That is why, I mean, there is no questions of escaping and all. Even the conditions of 3 crore I have complied with, my lord. So under any stringent conditions, my lord, I am ready to face the trial. My learned senior has correctly said that, I mean, this is not a matter of evidence. If I am found guilty during trial, I may face the consequence, my lord. Highly grateful, my lord, for having a patient listening.
Yes, begin.
Yes,
Oh,
please.
Yes, we are taking up the IA. Yes, what was your submission? We can begin again.
Oh, my lord.
Lordship, may I recapitulate the facts of the case?
Yes.
Lordship, there is a charge sheet laid by Latasil Police Station, and the honorable and the learned magistrate has taken cognizance of it for fraud on this court by the respondent number 2 in his anticipatory bail petition. Now, Lordship, the FIR was lodged in the year 2019. It culminated to a charge sheet in the year 2023. The respondent never raised a whisper. When the summons were issued, he rushed to this court for a quashing. He filed a luxury petition before my lords. Filed by the respondent in the interlocutory application. The entire petition is a bundle of lies, but we raised 3 issues before my lords. First, he stated that I was never issued any notice or summon to cooperate with the investigation. Second, he said that I was never summoned by the trial court and no documents were given to me. The Honorable Court, taking note of these facts, vis-a-vis comparing the facts of the charge sheet and the criminal petition filed by him, asked him that whether really you were not summoned by the police or you were never given any charge sheet. He came up with an affidavit before this court. In his affidavit, Lordship, he says that I was summoned once by the police and the trial court never summoned me. I applied for the certified copies of the order, but without applying for anything else, I was given uncertified copies of the charge sheet, which lies with the criminal petition. Now, Lordship, the question arose, if you are given an uncertified copy of the charge sheet without applying, is it possible? This court again asked you if the charge sheet was given, why the FSL was suppressed. He lays the entire facts on the court staff that they gave me the uncertified copy of the charge sheet, but suppressed the FSL. Now, my lords, these are the 3 factors which were taken by this honorable court when the petition was heard, reserved for judgment, and again released. And hence it has come before my lords. If we look at the criminal petition which has been filed, it has been it has dealt a severe blow on the sanctity of this honorable court by playing such a massive fraud, which is bizarre in nature, Lordship. My lords had heard me. There was an ad interim injunction on the trial court proceedings, which is more than 2 years now. And it has died a natural death. But since the word vacated is not there, I was asked to file an interlocutory, which is 1308. And there is an application for further investigation in the case. My lords will be surprised to know that the IO of the case, which filed a charge sheet in the matter for fraud and forgery on this court, has also been under an FIR under 156(3) by the learned magistrate Kamrup Metro for being hand in gloves with the accused. Lordship, the bone of contention with the present respondent number 2 is that he entered into an agreement with my mother to take 4 excavators on hire. He took them, did not pay, sold them off. Since the agreement was done in Dibrugarh, a case was registered, investigated, and submitted as civil nature without even the accused being summoned. On a protest petition, it came for further investigation, and then this respondent number 2, the named accused, rushed to this court for an anticipatory bail. Lordship, the forgery was noted then and there in the year 2019. I appraised this court of a fraud on this court through an affidavit, and looking at the bar, which is not applicable in this case under 195, I filed a case with Latasil Police Station. Now, Lordship, the case has culminated into a charge sheet. He did not raise a finger for 4 years from 2019 to 2023. In 24, he comes up with a luxury petition, which is criminal petition before my lords, that I was never asked to cooperate. I am such an innocent man. I have done everything great. But he plays another fraud is this criminal petition. There are 3 frauds, Lordship. First is the anticipatory bail. Second is the criminal petition before my lords. And third, Lordship, is the affidavit before my lords in this criminal petition. It is a case where fraud is overtaking fraud in this case, Lordship, one another. I have placed one judgment of the Honorable Apex Court in Prestige Lights 2007 8 SCC 449 that when you play fraud on this court, it's serious contempt. And when you are under serious contempt, you lose your right of being heard, your audience. You cannot be heard. Now, my lords had heard me in IA 1308 with the criminal petition remaining to be heard, and my lords had fixed the date for the respondent's response to my IA 1308, Lordship. That is the factual backdrop of this case.
Yes.
Yes, may I please, my lord. My lord, this criminal petition, my lord, basically it is filed for quashing the, my lord, order taking cognizance, my lord. And my lord, saying that there is no prima facie case, my lord, considering the materials on the record on the charge sheet, my lord, against the accused person. That's why this criminal petition has been filed, my lord, for quashing, my lord. With this honorable court has the power under 482 when there is a abuse of the process to secure the ends of law. This honorable court has the power. My lord, since this IA is basically for vacation of the interim order, interim protection granted by this honorable court. But very interesting, my lord, will find this IA, he has mixed up this petitioner in person has mixed up, it's written as an independent petition as under section 482. I have some doubt, your honor, my lord, that IA can be filed under section 482, and he has clubbed many prayers for in my otherwise this is my criminal petition. So for IA, so for vacation of the interim order concern, my lord, that is mental. But with this IA, he is praying all those things for further investigation, bringing all those facts into. Now, my lord, the issue now, my lord, whether I should start with my criminal petition or my lord, I should respond his IA, or my lord will be most probably will be disposing this. If my lord is disposing this criminal petition, my lord, then my lord, this IA will be considered in that together. It can be considered only, my lord. So this is my criminal petition is the first petition, my lord. And my lord, for this matter, my lord, if I am not wrong, for 4 times hearing took place, I have placed my comprehensive argument. But unfortunately, for the conduct of the petitioner in person last time, because he keeps on attacking the advocate personally. That's why last time also Lordship recused the matter despite repeatedly requesting him not to conduct in this manner. This is how again the matter is before this Lordship. My lord. So, my lord, if my lord is ready to proceed with main criminal petition, my lord, then I can argue, my lord, if my lord allows me to.
No, it is a fixed for orders, I think, because he has filed this IA.
My lord.
Need only to respond to that.
IA, my lord?
Yes.
My lord, my lord. My lord, if this IA, so far IA is concerned, my lord, now my lord, IA is saying that, my lord, that for vacation of the interim order. Now, my lord, this case, my lord, if sees the criminal petition, my lord, impugn order, my lord, first ground is, my lord, that without application of any mind, my lord, someone has been issued. Now, my law is very clear, my lord. Settle, my lord. There's a series of judgment on that regard, my lord. My lord, issuing someone to the accused person, it cannot be done mechanically, my lord. Some sort of exercise, my lord, exercise of mind, my lord. The order should reflect, my lord, that whether the materials that has been submitted by the, my lord, investigation agency, whether there is a case where the accused should be summoned or not, my lord. So there is the case, my lord, if my lord reads the impugn order, my lord, taking cognizance, my lord, then my lord will see, my lord, this is a non-application of the mind and mechanical issuance of the summon. This is first point, my lord. Another point, my lord, if goes entirely with the records, my lord, the official report, it is in the charge sheet itself, my lord. The police has said, my lord, that official report does not support, my lord. Official report is negative, my lord. So this is the reasoning given in the charge sheet, my lord. So in this account, my lord, there is no evidence at all, my lord, except the vague statement of the petitioner in person only, my lord. That's, my lord, this is a case, my lord. This criminal petition has to be understood, my lord, under what circumstances, my lord, this FIR happened to be filed against me, my lord. And, my lord, so far, allegation against me about, my lord, this suppression of the facts, my lord. May I make, my lord, clear, my lord? My lord, so far, my lord, in my criminal, my lord,
Yes, go on.
yes, my lord. In my criminal petition, my lord, I concede to one point, my lord, that in my criminal petition, my lord, it was admittedly, my lord, it was written as, my lord, the petitioner was not called for during the investigation. But, my lord, this was not deliberate, my lord. It is at the most, my lord, wrong statement. I admit to that statement. But, my lord, by making that statement, it is not a material fact where I made deliberately to get any advantage, because my case is not on that basis, my lord. My case is completely different, my lord. That's why, my lord, when this honorable court later inquired me to bring on the record on affidavit, my lord, and after due inquiry from the petitioner, my lord, that petitioner disclosed to me, my lord, that, my lord, once he was summoned by the police, my lord, that's why I have made, my lord, very clear in my additional affidavit I brought on record, my lord. And, my lord, knows, my lord, there is a distinction between false statement and the wrong statement, my lord. There are so many occasions, my lord. Sometimes wrong can happen after we are human beings, my lord. Sometimes we listen wrongly from the client also, my lord. But here is the case, my lord. The question before this honorable court, whether this wrong statement, by making this statement deliberately, am I trying to get any benefit from this honorable court? No, my lord, not at all, my lord. Deliberate intention to mislead this honorable court or to get any benefit from this honorable court, my lord. My lord, recent judgment also, the apex court has clearly made a distinction between what is the wrong statement and what is the false statement. Every wrong statement cannot be said it is a false statement. False statement, it will happen only, my lord, when the statement to the material facts has been deliberately, my lord, given, my lord, with a view to secure some advantage in the case, my lord. My case is hinges on the point, my lord, entire on the basis of charge sheet, my lord, on the basis of the impugn order, my lord. Apart from, my lord, other query, my lord, the objection written, my lord, other part, my lord, so far someone, my lord, no someone was ever received from the learned trial court, my lord. This, about this case, I came to know only when, my lord, the petitioner in person file a IA, my lord, for rejection for the cancellation of my bail, my lord, during the hearing of that proceeding before this honorable court, my lord. I came to know about this particular case, my lord. Then, my lord, then at that point of time, I wanted to have the status of the that case, my lord. Then through local counsel from the Gauhati itself, my lord, I came to know and about this filing of charge sheet, and I obtained a copy. Now, very interesting, my lord, allegation has been made. So for FIR certified copy, I obtained, my lord, all those things. Now, my lord, this charge sheet, my lord, it seems that this copy has not been certified, my lord. Now the question, my lord, for quashing 482, this certified charge sheet is not required, my lord. There is no such mandatory that certified copy of charge sheet has to be submitted along with. Now the question is, my lord, before this honorable court, whether this certified copy which I have obtained from the local advocate based at Gauhati, my lord, is there any something different from which the original charge sheet is before this honorable court? Have I done any manipulation with that charge sheet, my lord? This is the same copy which has I have obtained, my lord, and on good faith I have enclosed in my criminal petition. Is there any tampering with this my charge sheet, my lord? My lord's original charge sheet is before my lord. This is completely a preposterous, ridiculous allegation against me. And now, my lord, another very interesting question that has been raised is that about official. Now, my lord, this official report is in my favor, my lord. And when the charge sheet was issued to me, this official report was not given. Even 161 copies was not supplied to me. Only charge. And what are the documents available with me? I enclosed and I submitted. My lord, question allegation against me that I have suppressed FSL certificate. My lord, very interesting, my lord, the point is there. The FSL document on the basis of which my case stands, my lord, if that is made available to me, why should I suppress this FSL document, my lord? There is a categorical observation by the police, my lord, in the charge sheet that official does not support the allegation of the petitioner in person, my lord. And then, my lord, that is there. And I don't feel, my lord, anybody will, the document which is very much important for me, because my entire case is on FSL certificate, my lord. FSL report, man. Why should I suppress from this honorable court, man? What advantage I am going to get by suppressing the FSL report, man? If it is not supplied to me, 161 statement were not supplied to me. What are the documents available with me? I have enclosed in my copy. Or the original records, my lord, it is before my lord. That has been called from the lower court, my lord. So this is not the case. That's why, my lord, this entire this allegation is only for the sake of making allegation is making, my lord. But has to see, my lord, that what exactly the benefit that I am going to get with it. There is no suppression, my lord, and my entire criminal petition, basically because my lord will so go from the record only and look into whether there is a prima facie case to go for a further trial, or whether, my lord, that an order taking cognizance is in accordance with the law, my lord. These are the issues I have raised in my criminal petition, my lord. All these issues, my lord, these are not relevant to decide my criminal petition. If he says that, my lord, for vacation of the criminal petition, well and good, let him argue whether, because my lord will decide whether I have made out a case for the indulgence of this honorable court or not. My lord will decide. That's why I am before my lord. I am trying to satisfy this honorable court. This is a case, my lord, that the cognizance has been wrongly taken in violation of the law, my lord. And there is no materials where a person should go for the prolonged trial, my lord. These are my case only, my lord. Now all other irrelevant things, everything jump up. How, my lord, under IA, I have never come across that IA as a under 482 or 528 IA application has been filed, my lord. IA is a completely independent and substantive inherent power of this honorable court. If he has a grievances that, because he is himself is admitting, my lord, because he is asking for a further investigation, which implies that this investigation document is not enough, that criminal trial cannot go further against me, not satisfied with the investigation. That's why he has filed the application for further investigation. If it is so, application is, but he has not annexed this application here in this IA event, my lord. Otherwise, that application is pending there, my lord. He has a remedy there, my lord. But not in this way. In my criminal petition, he will mixed up all the things, my lord, and he will ask for in one everything, my lord. No, my lord. Everything has a separate cause of action. This is my criminal petition. This is not his criminal petition, my lord. Now, my criminal petition that order taking cognizance is wrong, my lord. Materials on the record, charge sheet, FSL report, everything, my lord. There's nothing where the, my lord, that this trial case should go ahead, my lord. Now he has come for IA vacation. Well and good, my lord. Then my lord will see whether this is a case, whether vacation of the interim order is required or not, my lord. So my humble prayer, my lord, 4 times I have already argued, my lord. My lord, this criminal petition may be considered and disposed, my lord, finally. And my lord, if my lord finds, my lord, that yes, there is a case, I should face the trial, my lord, I will oblige with that one, my lord, and I'll face the trial, my lord.
My lordship.
Yes.
Lordship, first of all, with utmost humbleness, I will like to brief this court or submit before this court that today we are here on 28th occasion when this matter has come up. On 27/9, it was reserved. It kept reserved for 11 months. And then again, it came for a fresh hearing. On 21/4, Lordship, it was further heard, closed for orders. And Lordship, it was listed for 6 more times. And when the last date,
What
the
shall we do
Honorable...
with all that now? What do you want now? Tell us. If you want the final hearing, we can do the final hearing also. If you want the IA to be disposed of, we can do that also. You tell us what you want.
Lordship may kindly come to page 103 of my IA, Lordship.
What is that?
Lordship, it is an annexure to a criminal petition filed by the respondent before the Itanagar bench. And he has submitted a statement of payments to the police of Dibrugarh, where the principal case lies pending investigation since the last 8 years. It's in his own handwriting. It's on affidavit, on oath before this court, Lordship. Dibrugarh police 80,000 and Jonai police 20,000. Lordship, the Dibrugarh case remains pending since last 8 years, deliberate perfunctory investigation, and the reason is before my lords on page 103, which is just here. I would also like to take my lords to page 121 of my petition, Lordship.
Yes.
Lordship, this is an FSL report. This is also a part of the same criminal petition filed by the respondent in the Itanagar bench. It upholds the agreement of the respondent with my mother to be. The subject matter of this quashing petition is the agreement with me. Lordship, at no point of time we said we have 2 agreements. If the agreement with my mother is true and genuine, the one he has annexed in this particular case is a false one. It's natural justice, Lordship. We don't need to apply any reasonable mind. Lordship, it is a settled proposition of law that no order or judgment can be obtained on a petition where suppression of facts has taken place, as such petition is non-maintainable in the eyes of law. When he filed this petition in 2024, up to 26, he kept silent that I was never summoned by the police. He never came up with an FSL that it could not be sent to the FSL, with the agreement that it could not be sent to the FSL. Rather, if he was so honest, he should have joined hands with me.
Now,
That
first
send
tell us whether you are arguing the IA or the main petition.
Sir, I am arguing on the IA.
If you are
The
arguing
main
on the
petition is
IA,
yet to be taken up, Lordship.
in the IA, you have made multiple prayers, but from your submission, you are only seeking vacation of the stay order.
At the moment, Lordship.
Yes, you are only seeking vacation of the stay order. So confine your submissions to that, why the stay order should be vacated.
Lordship, the stay order was granted ad interim without hearing us. It died a natural death when it was further not extended on 27/9/2024. Thereafter, it came
No,
up for
there was
fresh
no,
hearing.
no, just wait, hold there for a second.
Lordship.
That interim order says until further order.
Lordship can kindly
doesn't-
peruse the order dated 19/9, Lordship.
Yes, we have.
19/9/24,
Yes,
Lordship.
yes, it says until further order.
Lordship, it says until 27/9/24. Kindly peruse, Lordship. The order dated 19/9/24 says only up to 27/9/24, categorically.
But you showed us the order dated 21/6/24.
Lordship, 21/6, the ad interim was granted. On 19/9, it says extended up to 27/9/24. That's it. Thereafter, it has never been extended or continued. It has died a natural death.
So what remains?
Now, Lordship, we have prayed for a further investigation. It could not be taken up because the word vacated is not there as per the judgment of UP Bar Association. Hence, I was advised by this court to file an IA. Hence, the IA is there. Now, Lordship,
We don't know what court advised you, what if it is not on the record.
Lordship.
But the other prayers you are seeking, that cannot be done by way of an IA. You have to file an application before the magistrate or court concerned for further investigation. If that is disallowed, you can challenge that by way of a revision.
Lordship, it's already before the trial court, but it could not be taken because the vacated order is not there from this court. That is the humble prayer, Lordship. As per the trial court, the stay remains. The court is keen to take it up, but it will take only when the vacation of the interim stay is there, Lordship. And the order dated 99 clearly says it is up to 27.
My lord,
your stay order was only up to 27/9/24, very
yes,
specifically.
my lord, what happened, my lord, very unfortunately, my lord,
You
that
didn't get
matter,
it extended.
my lord, my matter was, my lord, reserved for the final judgment after hearing, my lord. Then after a very long gap, matter was again, my lord, came up, my lord, and at that time, my lord, that was not further extended, my lord. I accept that. Therefore, my lord, my humble prayer before my lord save is that, my lord, since my lord, this matter, my lord, pending since long a time, my lord. Therefore, my lord, the sore debt may be fixed, and my lord, for once and all, my lord, matter may be not in the piecemeal. Otherwise, also, my lord, if we say, my lord, that the trial court proceed with the matter, my criminal petition, it will become infructuous at all. Infructuous, my lord. My entire purpose of, my lord, pursuing this matter since last so many years, my lord, it will start. Therefore, my lord, one date may be fixed for once and all, my lord. Either it goes to the petitioner or it goes in my favor because this my lord will only decide, my lord. So because otherwise, my lord, piecemeal, if say that, my lord, okay, proceeding can go before the trial court also, my lord, and during the pendency of the criminal petition before this honorable court, my lord, this will cause prejudice to me, my lord. Therefore, my humble prayer, my lord, sore date may be fixed, my lord, and matter may be disposed, my lord, because now, my lord, only my criminal petition has to be considered because his IA, otherwise, he has been, my lord, petitioner in person with due respect, he has been, my lord, insisting for the IA, but from his own admission, this has become infractious, my lord. So, my prayer, my lord,
Never said so. If my lord can consider, it's up to my lords. I have prayed for the vacating order on the interim stay. I have never said my petition is infructuous. Where is the statement
lord,
out here?
May I submit, my lord?
It is up to my lords to decide. It's not my prerogative or your prerogative. It's the Lord's prerogative.
Your contention is that since it was up till a specific date, and that date having been passed, the order is no longer in force. But the trial court has difficulty in accepting that. Is it not?
Lordship, I will also add that he tried for an interim order on all the 12 occasions when it was further listed for hearing, but none of the court was inclined to grant him an interim stay. None of the courts. It is his submissions that he tried for an interim stay, but none of the courts allowed him.
My lord, may I?
Lordship, please allow me. I have something more to say. Lordship, when an ad interim stay can be granted without hearing me, it can be vacated also. He doesn't have to come up because it's an ad interim stay. It was never debated or argued. Now it is a deadwood, Lordship. And if he is so honest, the further investigation petition is before the trial court. Let it be heard. Let the matter be further investigated. Where is the wrong? Lordship, I will like to add something more here. The respondent number 2 has been charge sheeted for filing false cases under 182 IPC by the crime branch. And even in those cases, he has not challenged the case or the summons. He is just into bails. Once the bail is granted, he gets galloping dates of 8 months and 10 months, and it will never reach a conclusion in my lifetime, Lordship.
My lord, may I make a submission, my lord? My brother, petitioner in person, has a habit of, my lord, referring all the cases. I am not here, my lord, making a case of different. He altogether, as on today, he has filed almost 4 or 5 cases against me, my lord. I am before lordship only regarding to the one case, my lord. And my case is very simple only, my lord. My learned friend, if he refers all other cases, my lord, I don't have an instruction of all those cases. I won't be able to defend those cases, my lord. So my learned friend has to stick. What is the case before this lordship? My lord, will be also be very difficult to go through all the cases, whatever the petitioner in person refers. So I think I request the petition person, let's try to understand what is the issue in my case. My case is very simple. Order taking cognizance is wrong. There is no material to proceed further with the case. And that is supported by own admission of the petitioner in person that they have submitted further investigation, meaning thereby that investigation is there is no incriminating materials. That's why they want the further investigation, my lord. Now, my lord, my humble prayer, my lord, at this stage, my lord, this matter may be, my lord, with the convenience of this honorable court, my lord, one date may be fixed. Both the council may be heard, my lord, on that day, and there is not that much long argument. Also, I have to make, my lord. Only I have to disclose, my lord, why order taking cognizance is wrong, or whether there is material wrong. Otherwise, my learned friend has to stick to this case, man. Altogether, although, my lord, he has filed 4 or 5 cases against me, my lord. So he has a habit of, and I have so many things to say, but now this is not the right time, I should say, because my lord is not taking up the criminal petition. When my lord takes up, I will make the required submission. Otherwise, my lord, I'm restricting my submission, my lord, not bringing all the things here, my lord. So my humble prayer, my lord, a date may be fixed. Both this application may be taken up together and disposed of, my lord.
My lords, I have a humble prayer of vacating the stay, which has died a death. It's a deadwood, and it cannot continue. Only a vacating order is required. Criminal petition can come up as and when my lord pleases, but while disposing of this IA, the order of ad interim stay, which was up to 27/9/24, needs to be vacated in the interest of justice, lordship. It cannot continue at all because it is more than 2 years now that this order is prevailing without any legality.
Otherwise, my lord, my criminal petition, my lord, would become infructuous, my lord, and my approaching before this would serve no purpose, my lord. Piecemeal, this matter, my lord, it may not be decided in the piecemeal manner in which the petitioner in person is calling this honorable court to decide in piecemeal matter, my lord, because I have to make an exhaustive argument, my lord, why the entire criminal proceeding is vexatious. With ulterior motive, this has been launched against me, and this is wrong, my lord, to proceed in which with the manner this has been proceeded.
Yes, the whole problem seems to be because the order was reserved on 27/9/24, and thereafter
The
I don't know
reserve
what
did
happened.
not
It's
come up.
posted again on 29.
27/9, and Lordship, thereafter, whenever it is heard for last 2 years, Lordship, never
No, no,
any of this court,
thereafter the case came up only after a year, after the order was reserved.
Lordship,
I don't know what happened after that.
still listed.
And because
And
of
it
that,
was rejected.
my lord, that is one of the reason also, my lord, that earlier protection could not be, my lord, extended, because the matter, my lord, was again relisted after 1 year of the reserve of the this case, my lord.
No,
And
no,
this
no,
is how, my
no,
lord,
no, no,
I am
no, that
also
is not.
aggrieved to a I am also aggrieved to a extent, my lord. Therefore, my lord, this matter may not be decided in piecemeal. My humble prayer,
No,
my
no,
lord.
no, no, Lordship,
Please, my lord,
that is the
this,
wrong,
my
that
lord,
is the
if
wrong submission, Lordship. He
with
has prayed for
the
interim,
with
but
the
none of the courts
convenience,
were inclined to grant him interim. None of the court allowed him
my
an
lord,
interim
my
stay.
lord, my lord, my learned friend's argument is that already this order is not in force. Already that was not extended. So question of my lord again writing a order with the order is not there, and my lord saying that this order is vacated is also sounds bit unreasonable, my lord, because this
It
is
may
his order.
sound, but it is the law that a vacating order has to be
My
there.
lord, any clarification or any order from this honorable court, my lord, instead of deciding giving my lord piecemeal observation, my lord, may kindly take up this matter with the convenience of this honorable court and with the
My
convenience
lord,
of
my IA is a
petitioner in
separate
person also.
application, and
And
it
this is the
it's
matter, I
called a
think,
piecemeal basis.
my lord,
Yes,
is very.
I think we have heard enough for today. So we'll fix this matter for hearing on any date ready.
My lord. My lord, can it be on, my lord, petitioner in person? Otherwise, he will blame me that I keep on postponing the matter. You just suggest some date.
Maybe
Petitioner in
tomorrow.
person.
We can come tomorrow.
Tomorrow, no. What's the problem, my lord? Petitioner in person has only one matter, my lord. And my difficulty, my lord, today also, although, my lord, I have some matter I had to leave, my lord. And since my lord has asked that I should be appear, that's why. So he has that privilege of attending tomorrow, day after, for one case, my lord. My lord, but unfortunately, I am into the profession, my lord. And my whole.
My lord can fix it at his
My lord,
convenience,
13,
vacating the
my lord,
interim stay,
13,
Lordship.
13 of August, my
He
lord.
cannot take this court for a
13,
ride,
13
citing
August,
his
my lord. 13
occupation, Lordship.
August. 13, 3 August. August 13, my lord.
All right.
I am not, Lordship, comfortable with August. Maybe in the first week, if my lords can kindly keep, Lordship, because the 15th August, we have a lot of movement problems, Lordship.
Then 19
Coming from
August, was,
Calcutta.
19 August, my lord, I don't have a difference.
Lordship
19
can
August.
prepone it, not postpone it to his convenience.
Movement problem means, are you in the forces? What movement problem?
Lordship, to get reservations to and from Calcutta to Assam is the issue during 15th August. We don't get reservations throughout. And coming more than 1,000 kilometers to
So you
the
will be appearing physically.
Lordship, it needs to be addressed because perpetual fraud is being played. He is charge
Please answer
sheeted
my
under
simple
everything.
question. Do you intend to appear physically?
Lordship.
Yes, all right. Say that.
My lord, then can it be 19, my lord?
Then give a date.
Lordship, any day in the first week of August to my lord's convenience.
My lord,
I am not comfortable in the last weeks.
I have, my lord, some prior engagement already, my lord. This is the difficulty of the councils, my lord. My lord can understand that part. Otherwise, I am always ready to appear, my lord. It's only because of my prior commitment, my lord. Otherwise, my lord, very unfortunate. Otherwise, my lord, at the most, whatever the dates available, I have said, my lord. Otherwise, my lord, I'd love to appear, my lord. Any date may be fixed. But problem is that, my lord, this first 2 weeks, my lord, pre-engaged, my lord. And this is the difficulty with the lawyers, my lord. My lord can understand that part, my lord. So, my lord, I am free on 13 or 19 and 31, my lord. This date, my lord. And petitioner person has a luxury. He can appear at any time, my lord. So, I think it should not be a
How can
difficulty.
you count my convenience to your own ways?
I leave it to the my lord.
All right. If you can't come on 13, then we'll have to see the next date.
19, my lord, I can come, my lord.
Lordship, I have a matter where I am contesting his bail in the Supreme Court in an SLP, Lordship, in the last week of August. In person, Lordship, before the Honorable Supreme Court.
The last week.
Lordship, it's on the stages of finalization and it may come up anytime
All
after
right.
15th.
We are giving him on the third week then, 19th.
My lord.
Lordship, can it not be in the first week to my lord's convenience? A humble prayer, Lordship.
No, I have no difficulty. It is the difficulty of counsel for the other side.
My lord.
Since
He
my
also
lords
has
are
his
not,
commitments.
lordships are not disposing my IA today, let me be allowed to come in the first week and argue my IA, lordship, because the order is not being delivered today in the IA also.
All right. No, we are not hearing the IA again. IA, we will pass an order today.
Lordship.
Whatever be the order. But we are hearing the matter finally. That is what we are saying.
Lordship can keep it on 13th. We will try whatever it is. If not convenient, we will address through VC.
All right.
But each time, Lordship, we are
Give me-
conceding to this, to his dates.
Main criminal petition is this matter on 13th with the consent of both the parties. Release the matter again on
13 August.
13th at 2 p.m. Okay. At 2 p.m.
My lord, my lord.
Yes. In the is it already admitted?
My lord, this at most, my lord, I am also not that sure, my lord. I think
Silable, huh? If it is
it was,
already
it was admitted, my lord. It was reserved for hearing, final judgment, my lord.
All right. Then for hearing. Okay.
My lord.
Hearing.
Deeply aware.
So, Lord, so I am court number 21. I was in court number 21 on calling out.
Screenখন কাটিব দিয়া কেইটা কৰি Yes. This is for motion. What is this?
Not promotion.
The leave petition.
Petition was delay condonation was part lodge.
For delay condonation. Yes, what is this? Given a paragraph, it was under discussion. That's all.
Lordship.
Why have you filed this appeal? Have you gone through the judgment?
Lordship.
Have you gone through the judgment?
Yes, Lordship. But Lordship, yes, but victim statement is here, Lordship, deposition.
What is the deposition of the victim?
The victim deposition is Lordship, is read that accused is my husband. I was married to the accused 2 years ago in its arranged marriage. And at the time of occurrence, I was above 18 years, Lordship.
So what offense is made out?
And in the section birth certificate in Lordship, it was 2023, Lordship.
Who exhibited? Was it exhibited?
Yes.
You have not annexed the full judgment also. List of exhibits is not there. Exhibit P1 is the FIR. Then no other exhibits as per the judgment. You have the copy of the judgment?
Yes, sir.
Lord, I have already submitted. I have already submitted it.
Where? In your objection?
No, my Lord.
Separately?
Yes, sir.
This one? Yours is the same. Where is the list of exhibits, witnesses and exhibits? Then you have the communication, the correspondence, anything? Simply saying it, we were discussing, what kind of explanation is that?
The communication made by the
Like if we condone the delay and take up the judgment, there is a very good chance that we'll make very adverse observations for filing of this frivolous appeal. Turning pages will not unearth anything that is not there.
yeah.
Yes. So let's finish this off. Unnecessary wastage of court time. Third learned counsel for the learned additional public prosecutor. This IA has been referred seeking condonation of the delay of 188 days in preferring the connected appeal against an order of acquittal passed by the learned Special Judge Bozali in Special POXO case number 16 of 2023. Judgment and order dated acquittal order of acquittal dated 14/5/25. Is the other IA, this one, leave to appeal.
Leave
Leave is required.
see that last.
The reason shown for the delay in preferring the appeal is reflected in the instant IA at paragraph 3, which reads as follows. Paragraph 3 of the IA 541. Paragraph paragraph 2 also. Okay. 2. the respondent has filed an objection. Wherein it is stated that the applicant has failed to disclose proper and reasonable explanation with documentary proof for the delay. It is further stated that the applicant has also failed to explain any reasonable cause for the delay with effect from 23/8/25 till filing of the appeal on 20/05/26. As to what caused the appellant last line to কি লিখলাম till filing of the appeal. All right, full stop. Para. From the own statement of the applicant, it is seen that the discussion continued till 22/08/2025, thereby meaning that on the said date, the decision to file the appeal was taken. But there is no explanation as to what caused the further delay of another nearly 8 months in preferring the connected appeal. Therefore, far from showing sufficient cause, no cause has been shown for the aforesaid period of delay. Moreover, on a perusal of the impugned judgment and order, I am of the view that no manifest injustice has been caused, would be caused, if the delay is not condoned and the appeal is not heard. So, having regard to the above, the court declines to condone the delay and the IA stands dismissed. IA, the view of order passed in IA 45541 of 26. The present IA also stands.
Please, Your Lordship, kindly pass over for the day. Senior Counsel JC Gogo is out of session.
The prayer of learned counsel for the is the matter again on
Obliged.